Review of agenda.
Yep.
To my knowledge, there are no changes to the agenda. That's why I skipped it. Just like, nothing there. But if anyone wants to bring anything up, we're good? Okay. May I have a motion to open to the public?
So moved.
Second?
Second.
All in favor?
Aye.
We are open to the public for items not on the agenda. Once, twice. Seeing no one, may I have a motion?
So moved.
Second.
All in favor?
Aye.
Okay, we are closed to the public. Next up, presentation of minutes. We finally got all three of them done here. Kristen, I'm gonna ask us, we'll do these individually because certain people can only vote on certain minutes. And Kristen, I'm gonna ask you to help me on this one.
Of course.
So we'll start with April 15th, 2024. If you want to let us know who needs to abstain, or I have them printed, but now I don't know where.
You have them printed. So just one moment.
I believe Mr. Nardi and Ms.
I need to log into my,
to look at that.
yes, I apologize.
Okay, then we will move that to after, now I'm changing this. We'll move it to after
You can
unfinished
look it up.
business.
I just pulled it up.
Oh, he's pulled it up? Okay.
So for the April one, Richard's here, Jamal, Maria, Mike McGovern, myself, Dante, Candace Wiggum, and Matt and Emily.
Okay.
Plus Alexis.
Okay, so may I have a motion to approve the April 15th, 2024 regular meeting minutes?
So moved.
Second, all in favor, those who are
Aye.
allowed to vote?
May I ask who was the second? Mr. Wilson.
I mean, it's Jamal.
Thank you, Jamal.
Okay, so they are approved. Al, may I have the June
Sure.
17th? We're right on a roll here. Thank you,
Okay.
Al. I should've
You were
done-
here, Matt, Dante, Jamal, myself, Mr. Catanacci, Mary Van Horn, Candace Wiggum.
Is that the UAW one?
This is, I'm just reading the minutes,
Yeah.
meeting minutes from June 17th. McGovern and Ms. Teresi.
Okay. So,
I was here, but
you were here,
but we had to
did-
leave because we
was
couldn't
it-
hear UAW.
Yeah, okay,
Right,
and I
so-
did too. So it's
Yes.
Matt and everybody over there.
Well, Alexis, how does that work? Because there are
Okay.
other,
Yeah.
on various agendas, there are items that,
Yeah, you
for
can
example.
approve the minutes.
I
we
would,
can
Fine,
yeah, I would
because
say,
you're
right.
not approving the portion where you
Okay.
weren't here, but you
Exactly.
were present
That's
at the
not-
meeting and you
Okay.
can agree that they were.
Okay, so makes life easier.
Yes, agreed.
Yeah. May I have a motion to approve the June 17th, 2024 regular meeting minutes?
So moved.
Second?
Second.
All in favor?
Aye.
Okay, they are approved. Last one. Thank you so much, Al.
Oh, you're very welcome. Emily, Matt, Dante, myself, Mary Van Horn, Jamal, Mr. McGovern, Candy,
So the only person.
yeah.
Okay.
Rich was
Yeah.
So the only one was, okay.
I was not, I
Yeah.
was missing.
Yeah. May I have a motion to approve the July 15th, 2024 regular meeting minutes?
So moved.
Second.
All in favor?
Aye.
Okay, approved. We have no resolutions for approval. So now we move to unfinished business. Craig and Janine Mattis, 1217 Old York Road, Block 8002, Lot 26, in the Amwell Valley Agricultural District. A minor, well, it was a minor subdivision with variances. There may have been changes from there. I will ask Mr. Mattis, are you prepared? Are you ready to go?
Just one moment.
Yeah.
We would like to take care of some administrative. So while we're starting this testimony, I just want to make sure anyone who has had any absences have been caught up to speed. Mr. Nardi, have you been able to watch the March 18th,
Yes.
2024 meeting?
Yes.
Thank you. And Mr. Catanacci, were you able to watch the March 18th, 2024 meeting and also the July 15th, 2024 meeting?
Yes, painfully.
Thank you. Okay,
And
and that would be
that's
everyone.
everyone? Okay, thank you very much for doing that.
We just wanted that for the record, so everyone up here tonight is available to vote, because they certified that, for those who are absent, certified that they watched it, so they're eligible to vote tonight if it gets to a vote.
Okay,
Thank you.
Mr. Mattis.
All right. Good evening, Board. Thank you for having me again tonight. We pretty much left off last meeting with a lot of new information that you guys wanted to review, have your planners review. And at this point, pretty much there's really not too much more to contribute to the minor subdivision that we have proposed tonight. We've cleaned up the impervious coverage. We provided what would you call it, like a spreadsheet, basically, for your professionals to see the impervious coverages broke out of our maps. And then we basically had presented everything that we had to get to the point where we're at now on lot size averaging. I think.
And Mr. Mattis, before you go any further, I don't want
Yes.
to, do you both recognize that you're still under oath for the testimony you're giving tonight?
Yes.
Okay,
correct.
thank you.
Yep. So basically, we've come to the point where we're at with lot size averaging. We've presented the original concept plan that showed a larger portion of property being sold to the county. And with that agreement with the county, the property owner went into the agreement with being able to develop 2 smaller lots if they were able to get perk on the property. We've presented that concept plan. We have now adjusted from the beginning our minor subdivision to now a subdivision that has no variances. We're working on actually removing existing variances to comply as much as possible with, your zoning ordinances. The only other thing that I have to add to our subdivision is on today's tax map, that I requested from your township. It currently shows a 25-foot wide access easement. Kristen, can you check to see if this was submitted
I do not
digitally?
recall seeing that.
I wanted to ask, now, has anyone seen the tax map?
No.
No.
Okay. So I have copies of the tax map.
So we'll mark this as exhibit 8A8, right?
And then this is a enlarged version of that tax map. And then so what we're handing out right now is the common access driveway easement. This was originally proposed back in 2006 when this concept plan was approved by the board. Where the property line is on the property on the left there, that is still the current property line that has the common access driveway. And this,
Excuse me, can you just give us a second while we pass this out so we can follow along? Yeah, I want to pay attention to what you're saying.
okay, sorry.
Yeah, no.
It's 2 pages, correct?
There should be 3.
Three?
There should be the proposed and, and then 1 and then an enlarged
I'm
one,
passing them
so
down.
you can see.
Yeah, but what he got is different from what I have, and I have more of the
What?
same. Yeah, and I have more of this. So it looks like those are page 2 and 3, so these.
And Mr. Mattis, just for the record, is this plan the same as last meeting?
These-
It's all the
Different?
same. It's all
Okay.
the same. I'm just,
I just want to make sure I know the
Yeah.
exhibit, that's all.
And you need 3 here.
Here's 3.
And do you have any? down there?
No.
No,
You have
we have none.
This one.
We have
Okay,
none at this side of the room,
It's number
Another
two.
one.
Okay,
but we play nice and we share if you're short of copies.
2. There's more coming. I'll get you one. I'm just trying to make, instead of passing them and getting them out of order, just bringing them.
I think Rich is missing a front page.
Oh, you, this one, you should have 3 pages. If you don't, let us know.
It's 3 pages.
Yeah.
Any more?
One more.
Here you go.
And does Smith have one? Do you have one?
I don't.
Oh,
I'd like
one more.
to mark them.
One more?
One more.
Thank you. I'm just gonna mark this as A9 to be safe, as the amended plan. Is that accurate?
This one here?
Yeah, is
Well,
that
this
accurate?
is the original concept plan.
The original
The
from,
one that you introduced last month.
Yes, correct. This is the concept plan.
Okay,
I
I
held
just wanna-
off with the common driveway information last month.
Okay, I have
Because I
it.
had presented so much information, I didn't want it to get, just more overwhelming than it was.
yeah, so this would be the initial concept plan from the county from 2005?
Yes, from the county,
All right, so
correct.
it's A2. Okay, thanks.
Okay. So on the county's initial concept plan, they indicated the common driveway access, which is between the 2 properties after subdivision.
Where would I find that on which of these?
So that's on this one here, okay?
Okay, so I can't see it.
And then the one that is the Hunterdon County Health Department received in 2006.
Yep.
Is the actual one that was received. And on there, it says proposed 25-foot common access easement for the 2 properties. And it says, to be used by proposed lot 2602 and proposed future minor subdivision lot created from lot 26 lands remaining. And that's what we're going for tonight. And then the other 2 maps that I provided you are conditions on your current tax map that still show a 25-foot wide access easement on today's tax map in your township.
Mr. Mattis, could you show us on the map that's your application where this is, this 25-foot?
So, on the county one or on ours?
On yours, because I'm not familiar with that map, but I'm familiar with the one that you presented.
They want our subdivision. Do you
We
have that
did.
one? Or you just have the impervious coverage one?
Oh, yeah, there we go.
Okay, so this is our impervious coverage one, but it also shows the common access.
I see,
easement.
thank you.
Yeah, that's the easement that
Okay.
we would be
Thank you.
utilizing
I
for the
understand.
property.
It is on the plans that we submitted originally.
Okay, thank you.
So I just wanted to make clear where that came from, and it still currently exists on today's tax. map.
And do you know when that easement was created?
It's got a date on here.
The easement itself?
The easement itself was created in 2006 during the subdivision, the first subdivision, when they created lot 2602.
Oh, I see.
It was put in for the second lot.
So when, resolution, planning board resolution 20, as was it, 2006-20?
Yes.
When that was approved, that's when it was
That's when
created?
they went through with the state DOT to get it,
Got it.
the driveway.
Thank you. I understand.
Okay. So I just wanted to clarify where the common driveway access came from, and that it is still on today's tax map, in your records. Do you want to talk about the impervious coverage?
Yeah, sure. So we submitted impervious coverage summary for a minor subdivision. And the existing lot as it stands, the total impervious coverage is 41,500.
Sorry, Mr. Tequina. Alexis,
Yeah,
I believe he's going to be referencing a form that was submitted.
Okay, so we'll mark that as A9 if we're referencing that.
Yes.
It's submitted to the board already.
Was submitted 10 days prior, so I don't know if you need
That's
to
okay,
mark
we're
it.
just gonna mark it for the
Okay.
record. It'll be A9. Thank you.
So the existing lot as it stands today, the impervious coverage is 41,534. The proposed lot, which the 12.1 acres, that will be 30,474 square feet. And the remainder lot is 8,375 square feet.
Remainder lot being Lot A, and Lot A is how we're referring to it? these-
Yeah, so this lot, the lot A is 8,375.
Is it the smaller of the two
Yeah,
lots?
the smaller of the two, correct.
Thank you.
Sort of the original,
Yes, where the house
it's
is.
where the house is,
Thanks.
the lot with the house is Lot A.
Yes,
That's how I
correct.
think about it.
Thank you.
Okay.
That was, all the impervious coverages broke out into a spreadsheet.
And, Mr. O'Brien, is this the first time you're seeing this?
No, I had reviewed that. It's in my letter that when I looked at that total, you're over the impervious limit. Is that correct? In your calculation sheet, you have .086.
Yes,
The requirement's .08.
.08 is what is
8% on
permitted.
that lot.
Right. So, and I don't know that, when I calculated that, I got a different total square footage on,
higher or lower?
let's see, would you have three? I got
I mean-
lower on lot A.
Did you, because we're removing a couple of those.
Right, so I would just ask that you double check those numbers.
Because this is. No, remaining lot is this one.
Yes.
So the remaining one isn't the 10,000?
It's less than 10,000.
Yeah, isn't that lot supposed to be 10,000?
The requirement for the remaining lot is 10,000 because it's, because of its lot area, but the other lot is greater than 3 acres and it has a requirement of 8% impervious coverage
8%.
on the overall lot.
Does that take into account all the concrete pad and everything we're removing?
I'm assuming that he did it that way.
It looks like, just looking down at the total, if it was 41,534 before, and the proposed lot is 30,474, would seem like the remaining lot should be the difference between those two, and it's not.
But what's red is coming out.
But
Right.
that's not the,
But that's not the total
total,
line at
yeah.
the bottom.
You told him to take it out?
I told him to take it out, yeah. Maybe he didn't take it out.
Oh, we could double check. Can we have a minute to double check?
A minute, yeah.
A lot of people doing the math right now. I would do it in a spreadsheet.
I'm not reliable enough. I'm not gonna try.
I just did these two, just for.
Yeah.
Pretty easy math there. In the interest of time, Mr. Mattis, may I ask, is it your intention to change, to make to comply with the impervious coverage requirements? Is that your?
If there's something else I need to remove, we'll remove it.
Yeah, I can provide a little bit more detail to that. The current impervious coverage is proposed at 8.6%. which would need a reduction of around 3,000 square feet of impervious square footage to meet the 8%. So, just to provide you with a little bit more specific information on how much would need to come out, based on the numbers that were provided. And I know it has been something you've said throughout your testimony, that you're willing to sort of amend this, remove things on site to
Yes, we're
make it
willing to
compliant.
make the changes, but I thought we had removed enough.
Well, Mr. Hajar, could I just indulge me for a second? I have it done by a spreadsheet. Can I read off the numbers I have here, and you check it off against the little table that you had?
Sure.
So I have 870 for pavement, right? The apron.
870,
I have
yes.
7,021 for the big barn.
721,
7021.
okay.
And then for all the other barns, I have one is at 845.
845,
One's at 896.
896,
One's at 814.
yes,
One is at 681.
yes,
One is at 317.
yes,
The new dwelling is 446.
yes.
4476?
4476, thank you. I just got new glasses today. Bad idea. Sorry about that. And the concrete pad is 14,871.
Yes,
I get that as a total of 30,791
so
for impervious.
the one you're missing is,
But we're removing the 317.
Yeah, you're removing the one barn.
Yep.
Oh, you're removing that because I have that added in at the top.
Yeah, because that one has to come down because of the property.
and we're removing the 823.
Yes.
Well, I don't have the 823 in there.
You didn't
but
call that out though, but you called out the 317.
That one's coming down?
Yeah.
Or
Yeah,
being
it's in
moved in?
red.
No, that one needs to be removed because of the property line in the back. We want to try to get rid of that variance.
Oh, I thought you were just moving it in, like
Oh,
relocating
no,
it?
no, no, the one.
The other one is.
No, the one all the way in the back is going to be relocated forward to.
Does
off
that say
property.
remove?
That one's going to be moved forward.
What about the 317?
That's that little red one.
But that's on the other lot. Oh, no, wait.
That's 260. 317 is right here.
317 that says coming out?
It says it's staying.
That little one's being removed. It doesn't, I don't think it says remove on your map there, does it? For the 317?
Oh,
It's next to the silo.
That one's sitting on top of the concrete
That's
pad.
true.
It's on
So it's the
pad.
same. You're
Yeah.
right. So it doesn't count. All right, let me take that out.
Yeah, it's the one with it.
Let me take, because it wasn't labeled. All right, so now I have the same square footage that you have on your spreadsheet of 30,474. And when I divide that by your lot area, what's the lot area? 11 acres, correct?
No, it's more than that.
What was it?
12.5.
It's 480,467 square feet.
Yeah, that's right.
Yeah, 11, okay.
How many acres?
11.
So 467 square feet. So I get a coverage of 0.06. 0.06.
So I'm gonna, in the interest of time.
0.063. I think we're
I'm
good.
good. I'm good.
And I can,
Go ahead.
so I was gonna say, Mr. Mattis, you've represented that you would remove any structures that would put you over the limit for the impervious.
Yeah, I would try to take those.
Yeah, so it could be a condition of approval, and it looks like we may have remedied it anyway, but if the board were inclined to grant the relief, that, it would be subject to board engineer's approval, for the impervious to make sure it's under the limit.
But it looks like those numbers do.
Okay,
But we'll
so then if
still
you're,
look at
if you're you're okay with that now, then that wouldn't need to be a condition, but,
Correct.
okay. We fix that.
Thank you.
Do we
That's
know
good.
in official application what is in and what's out? Like, where is that represented in writing?
It's on the map that he has here.
So that map says it's removed?
Yes.
Okay, thank you.
Thank you.
So, can we move on from impervious coverage?
I think we're good. Thank you.
Do you have anything else, Mr. Mattis?
Okay, so okay, yeah, it was good.
Yep.
Okay. So last we left, the last meeting is the board was really kind of concerned about the passage of time. I spoke to the property owners, and I believe Norma Zimmerman has sent you a letter, and I think she would like to speak upon it also.
Alexis,
What was that?
may we enter the
You
letter?
can pass it out, yeah. I thought you should. You can't be here anyway. So we're gonna mark this as a, or wait, hold on. A9. A9 is the letter.
Can you give us a few minutes to read this so that we are up to speed before she starts
I know.
speaking?
A9, yeah, sorry. I missed one.
Kristen, do you have any more copies of this letter?
I just handed.
I have an extra one.
I think there were a couple of people who were asking for a copy. It's part of the record, so there's no reason not to share it.
Do you need more letters? Is that what you're looking for?
Just need a couple copies if we had them.
There's a whole bunch right here.
Oh,
Just have that.
yeah, Mr. Wolf wants one. Just a couple. So we're just gonna test the couple. Yeah. We had enough time?
Yeah.
Okay. Sorry, I'm not gonna give you time to read the whole letter. I should have done this. I'm sorry? Is everyone else read it? Okay. Mr. Mattis, we now have the letter. How would you like to proceed?
I guess if you have any questions, and Norma, you're willing to speak upon the letter that you have written.
So, Ms. Zimmerman, if you're gonna come up, I'm gonna swear you in, okay? It's okay. You can sit either with Mr. Mattis or right behind him, whatever works. So, Mrs. Zimmerman, can you just raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Absolutely.
Thank you. So for the benefit of the board and the public, it might be a good idea just to summarize it, and then the board can ask you any questions.
Okay, the reason I believe in the beginning was why it took so long. And my father was trying to do the best for all his grandchildren and his family before he passed. My two sons were the youngest, and at that age, there was nothing they could do with that lot of land. And we kept it for them. Going forward in years, my youngest son was diagnosed with brain cancer, and that was our priority. And there was no money for doing anything with surveying and all that. It was just a forgotten thing at that point. Now that as my son gets older, my one son, he can't afford to live, to build a house, to take that land. So we decided to sell it. And we were very grateful for Craig and the things that have transpired, because we feel it's all in good hands. I don't know what else. Why we didn't have it surveyed and all. We didn't have the money for that. It was touch and go. My son is still here. He's still has a lot of health issues, and we would like to have this money to maybe do a little extra with him and live a little more comfortably in our later years. Questions? Did I cover it?
I have one question, and thank you for sharing. I know that
It's not an
in your
easy
letter,
thing.
it's not easy.
Not an easy.
In your letter, you stated that the county was talking about an eminent domain. Something like that. That basically, was it your father did not want to sell the part of the land, and there was some.
He always wanted to keep it. You know, he always wanted to, my uncle and him, the two farms, he always wanted to keep it, but he couldn't afford to.
Yeah. Can you talk a little bit about what the county, where you're saying that the county started to imply they may use eminent domain to acquire the approximately 23 acres?
Okay, some of that I'm not.
Norma wasn't involved.
He was more involved in, my memory is not, it was somewhere else. Do you know?
Mr. Zimmerman.
So, Mr. Zimmerman, you can testify, but do you realize that you're still sworn?
Correct.
Okay, go ahead.
Yeah, so what happened was when the county started with the fairgrounds, I guess that fairground was on for 2 years or so. And then the county came to Rex and said they needed 23 acres to put septic in. And it was like the way they were gonna do the 26 acres, they weren't gonna give them really any money for it. They said, look, if you don't really sell it, we're gonna take the land from you. And he was like, and then they kinda came up through the year for taking all the land, the 40 to 50 acres in the back. And that's where it ended up that the county got the 50 acres. We weren't gonna sell. We would probably still own the land to this day, But they said that they needed the land to put septic in. To this day, there's no septic over there. You know,
So you ended up selling to the county?
selling it to the county. And the deal with the county was we were gonna get the two small building lots out of the deal to make up for the difference of the money. Basically, they weren't giving us any money on the land they were taking. So they said, well, what we'll do is we'll give you 2 building lots that you can sell to kind of make the difference up in the money that we're paying you, that you can get it back another way. And that's basically what it was.
And you were fully involved with my dad on that,
Yeah.
to the meetings and all, yes.
And Mr. Zimmerman, when the land was transferred to the county, it was as a sale of the land?
It was sold to the
It
county,
was sold.
correct.
Okay.
Was there a price?
What did he get for you? I forget what they paid an acre.
So the county, you actually didn't give the land, they didn't give the land to the county, they sold the land.
They sold the land to the county, yes, but the county was gonna take the land if we did not go along with it.
But Mr. Zimmerman, it sounded like you also said they didn't give you full price for the land.
No, they did not.
So I mean, I know, as a matter of the Constitution, when the state or a county takes land by eminent domain, they have to give market value. It's a requirement, right? So, did you not get more than the market value that the county was offering? Do you know?
No, I can't answer that question. I don't know.
Mr. Zimmerman, was your father represented by an attorney? Did he have
Yes.
attorneys?
Oh, yes, always.
At all times?
At all times,
always.
correct.
Okay. So what your understandings may have been different than what the attorney told you. You didn't participate in all the conversations between
No,
your father and
100%,
the
not at
attorneys?
all,
What
no,
most?
not at all.
The one thing I will say, just for the benefit of the board, and I wish I could put my hands on it, I do believe, let me hold off, let me find that document before I say anything.
Sure.
If there anyone else has any questions, I will find it.
I guess I do, of Ms. Zimmerman and Mr. Zimmerman. When I look back at the Planning Board Resolution 2006-20, were either of you involved in this language that's in the document that says, quote, "Next year, soil tests will be performed on the remaining acreage near Route 179, and assuming the soil tests are favorable, the applicant expects to return." Either of you
Yes.
have any knowledge about that?
Yes, well, not that knowledge, I just know at the time that they were perking our daughter's property, Jennifer's.
Yep.
We were gonna perk, they already had the machinery, the engineer, everybody there.
Right.
So we were gonna perk that, and then we were gonna come over and perk ours at the same time.
Yes.
Then it came up that, well, the perk's only good for so many years, okay? And then we were like, well, no, not now, we'll see what's going on. And then we've been dealing with our child with cancer. I mean, I'm talking going to Boston for brain surgery. I'm talking like major dealing with your kid. You know what I mean? It's not like.
And when did that start,
He
the
started
health
that, it
issues?
started in like, I would say, he was diagnosed at 18 months old. He had a brain tumor on the stem of his brain. He had surgery, chemotherapy, radiation.
It's horrible.
And it's been, I don't even want to go to, it's a nightmare, believe me.
No,
It's
it,
nightmares.
I mean,
it sounds like a hard thing for a family. I was just trying to ask, when that was, since, we're talking
In
about 18.
2007, he was in Boston having
2007.
brain
Oh,
surgery.
Fair enough.
yeah, I mean.
That's
To
fine.
the surgeon there.
Yeah, I don't mean to pry, I'm just trying to get an
No, it's-
understanding.
Oh, yeah, no.
That's
it's
No,
fine.
you have the right
yeah,
test.
He was diagnosed when he, in like 94, but like she said, in 07, we're in Boston. He's having, they called it moya. Brain, they had to take arteries from his
face.
outside of his face into his brain, because his brain doesn't get any
He
blood.
was having strokes
Yeah.
at that point.
Okay.
And now he's in
I think
what
we'll,
they refer to as early dementia because of the damage from the radiation. So
And
thank
here
God
has,
it's still ongoing.
here has the Has any property been sold at this point, or is that sort of contingent on this application?
I believe it.
Continue.
So it hasn't been sold yet? Okay. Thanks.
That's generally how it works.
I assume so, but I wanted to
It
ask.
depends on how their
because
contract's written.
It's been a
if they're
long
even under a
time, so I
contract.
didn't know if,
It's always been
Transaction
family,
happened.
family land, family, you know.
Anyone else have any questions for Mrs. Zimmerman or Mr. Zimmerman? Okay. May I have a motion to open to the public
so moved.
for questions to this witness only on the testimony given? Any other, you'll have an opportunity to address any other issues later, just on the testimony given.
We had a first.
So moved, may I have a second?
Second.
Open to the public for items, for this, questions for this witness only. Seeing no one, I have a motion to close.
So moved.
All in favor? We're close to the public. Like to hear, thank you so much.
Thank you.
Like to hear from our board professionals, sort of summarize where we are from the application standpoint, how they meet the standards or do not meet the standards. Any outstanding questions?
Yeah,
Have the
thank you.
witness.
So, I think we've had a lot of information. I really just want to kind of get back to the ordinance quickly for a moment, just so that the board's aware of what really we're looking at and what the requirements are. So, it's clear that lot size averaging is what the applicant is requesting here in their concept plans, and they've provided all of this historical information about land sold to the county. So just to walk through the lot size averaging requirements of section 92-91H2A. The minimum residential lot area shall be 1.5 acres. The plan complies, both proposed lots are over 1.5 acres. The maximum dwelling unit density. This is where there's a bit of two options here, and I think this really is the ultimate decision, is that what the board needs to recognize is whether that county land should be included in this application. That land that was given to the county, does that land count as the overall tract area? And if you note, the maximum dwelling density is 0.1 units an acre. Including the original land, the overall tract and the concept plan that has been shown, that the density complies. It is under the 0.01 units an acre requirement. And just as a note, where that 0.01 units an acre comes from is because the minimum lot area is 10 acres. So basically 1 unit per 10 acres. So that's where that 0.1 density comes from. It's a even equation for the number of units that you can build. So should that extra property not be sort of viewed as a part of this, then this is over the density requirement by 0.06 units an acre. It's at 0.16 units an acre, should the board find that. Number 3 of the requirements, each lot created by the subdivision shall satisfy lot suitability requirements. I believe there's been testimony provided and Rob confirmed. Number 4, all lots created under the subdivision shall be deed restricted against further subdivision. That testimony has been provided to that fact. The applicant is strongly encouraged to submit a concept plan of the lot size averaging plan to the board for review and comment. Strongly encouraged. I believe that the applicant has indicated that that concept plan back in the day satisfies that requirement. And number 6, the design of the development utilizing this option shall foster the following objectives: retention of large contiguous farmland areas, stream corridor and wetlands preservation, steep slope preservation, overall site design, reduction of impervious coverage, reduction in the amount of non-point source pollution entering the surface and groundwaters, traffic circulation, and the site's natural features, topography, and relationship to open lands on neighboring parcels. I think that the applicant has provided sufficient testimony to satisfy those requirements there. And just want to, we haven't talked about these again in a while, but the bulk standards for these lots, what they're required to meet,
I don't feel the need to go through everyone one by one, but the only outstanding issue was that impervious coverage question that we worked out earlier today. And all of the lot area, lot width, lot depth, front yard, side yard, rear yard, max building height, and max lot coverages are all in compliance with the ordinance as written and as proposed by the applicant. So that's just kind of the X's and O's. I think it was important to sort of get back to that on what the bulk requirements are and that they are all met by this application.
So there wouldn't be a D5 variance?
So that is the, I wanted to touch on that a little bit more. That is in the instance where the board should find that that county land doesn't have anything to do with this application, then what is being proposed is 2 units on roughly 12 acres, which would trigger that variance.
Gotcha.
I should have clarified, made that more clear. So thank you for asking. But that would trigger that variance, and that would be a jurisdictional issue with the board too. So if we have to cross that bridge, we'll have to get into that with Alexis. But I just wanted to lay it all out there. Here's kind of the 2 real situations that we're looking at here. And what it would result in, so that you have a picture.
Understood, thank you.
Before we address that question, which, as you said, seems to be the crux of the matter, I had a question about your item 6 here, around the design and of the development utilizing this option shall foster the following objectives. Retention of large contiguous farmland areas. How does this fit that criteria?
So,
Could you
again,
explain the definition here?
Yeah, so this is where lot size averaging kind of where it comes from is you want to set aside these larger tracts instead of just having sort of sprawling development. So what basically in this instance, I would argue that the preservation of all of that land off of the road the purchase of that land by the county is a large tract of land in a place that's sort of set back off of the road, and it really fosters that retention of larger areas that are unlikely to ever be subdivided again in any fashion.
But not farmland specifically.
Correct. Yeah,
Okay.
correct. I mean, and foster the following objectives, again, is very loose language, and it's, again, there are other portions of this that do relate to steep slope, sort of site design, and sort of the way that this has been laid out is really fostering the benefits and meeting the ordinance requirements as far as the bulk requirements go.
Great, thank you.
Yep.
Oh, yeah.
So that,
I have a question.
oh.
Can he answer, can Mr. Mattis first speak?
Excuse me?
Can I ask Mr. Mattis to address the
Oh, sure.
question I just put out, and then you can take it, Rich?
So that 50 acres that you were saying that wasn't being farmed,
Right.
they do hay for the fair.
Oh, okay.
So they farm that hay that is now used this
All
week.
right.
This
Note-
week for the fair, they just actually farm. They cut all the hay off of that property for the farm.
Yep, duly noted. Okay,
So-
great. All right, thank
It
you.
is being used
All right.
for farming.
Sorry, Rich.
Does it make any difference to you whether the land was, you said, and we've heard it 50 times, that this land was given to the county. It was actually sold.
I understand that. I don't think anyone's trying to purposefully make that.
Well, the question is,
interpretation.
doesn't that make a difference? Does it, in terms of an equitable argument or whatever type of argument you want to make, doesn't it make a difference whether or not this land was sold with attorneys in an arm's length transaction by someone other than the people in this room, right? Doesn't that...
Does it make a difference as if they sold it or gave it? Yes.
Yes.
it makes a
legal
difference.
question?
Fine.
That's the question.
But,
again,
and do we
I
all,
don't really
do we
feel
all
like this is a
understand that it
planner
was
question.
sold? Do we all
So-
understand that it was sold?
Mr. Yeah, so at least to the way the plain language of the ordinance is written, it doesn't specify whether or not it has to be, if we're lot averaging, right? It doesn't specify if it can only be through gift or by purchase. So conceivably, at least applying
I
that.
understand, Alexis, but doesn't it make a difference in terms of our considering whether we're going to deal with that 50 acres, that the large parcel, in terms of this application How many years later? 20 some odd years later?
I think you can, so at
I
least.
can speak to it
go
from a
ahead.
planning perspective. There will not be a house built on that land, so it does make a difference. The intention of lot size averaging is to set aside land that will not be developed with additional housing. And I could say that land is not intended to ever become additional housing.
Well, and
Which land? The
Sorry,
the 11
the
acres?
50 acres, sorry, yeah, the 50
The
acres.
county's land is
Yeah.
not.
but the issue is that subdivision was anticipated as part of the agreement that they had with the county, which was acknowledged by the township.
Well, that's your understanding.
That's your
of it.
I
understanding.
think the evidence is pretty clear.
Well, I think others may
Let's
disagree,
hold-
right?
let's
So
hold off
the-
on
the
that
que-
until we're getting to the
I think the
point.
point is to
Let's
ask the
ask
planner
the
if he
planner.
has
Yeah.
some professional opinions about how we should look at that and interpret that issue.
Yeah, no, to answer simply, it does matter that it was not gifted and that it was sold.
And
It
when
does
you talk-
make a difference.
And in point 6, when you talk about retention of large contiguous farmland areas, you're not talking about this parcel, these parcels that are before us. You're talking about the 50 acres that was sold. Because I don't see how this application in any way retains large contiguous farmland areas. Tell me where I'm wrong.
There's 40 acres that are being farmed because this
No,
agreement
you're
that was
You're
made.
talking about the
Yes.
as I said, you're reverting back to your 50 acre.
Yeah, yeah.
Right. Assuming that transaction 25 years ago is not, assuming that is not before this board. But what is before this board is the parcels that we're dealing with.
Yes.
Right?
Yeah.
Approximately 13 acres.
Yes.
Right, in a 10-acre zone, and you want to use averaging in order to put two homes on 13 acres. The zoning ordinance requires 20 acres. 10 acres, it's minimum 10 acres,
I understand.
correct?
I understand. Yeah.
Right. And for everybody else in this township, it's 10 acres.
A lot of people could go for lot size averaging if they wanted to.
But
I think.
Well, if they meet the criteria.
If they meet the criteria, correct, yes, yes, yes.
I think too, Mr. Hadnachi, some of it, and it's a question that, and I'll speak to this too, that the ordinance simply does not give an answer on what size lot should be considered. It does not, we don't really have any guidance from the clear language of the ordinance, whether it should be the 62 acre lot that we're thinking about, or whether it should be the 12.5 acre lot, right? We don't have any guidance. That's going to be for the board to decide tonight, right? And we could talk about that later, but at least with what you're talking about, right? The question of whether that last portion, I think it's relative, right? So if you are going to be considering the 12.5 acre lot, right? What is a large contiguous lot, right? 10 acres might be a large contiguous farming lot, but when you think of it like that, right, as opposed to the larger right, the larger 62, it's not so large. But if you think of it as the 12 lot that's getting split up, 10 acres is still pretty big. Maybe not here in East Amwell, but I think it's just relative, and the ordinance just doesn't give us any more guidance than what's here. Does that help answer your question?
Well,
I,
it gives its
but
plain
the answer
language.
to my question, I think, is that without the 50 acres that they made a deal with a deal with lawyers, right, with payment, many years ago, and the county can't bind East Amwell. I mean, suppose the county said, you could put 12 houses there, 14 houses, 36 houses. And we're bound by that because the county, because the county wanted to.
Are we getting into
No,
discussion?
let's not.
Can we finish?
No,
Can we
let's
finish
go,
with
let's
testimony?
go on
maybe?
to the finish with the testimony. Thank you. Mr. O'Brien, do you have any more?
I just have the comments in my letter, submission to the Hunterdon County Planning Board. I don't think that's been done yet. Are you waiting to see what happens here?
That's correct.
So that could be a condition. A Soil Conservation District, the Health Department, the DNR Canal Commission, again, you'd submit to that, depending on if the board acts favorably here. And then there's other items required for the map filing law, which Mr. Jar can go through, and that can be all conditions of approval, should you act favorably on it. And we could take a look at that plan to make sure that it meets those. That's really all I would have on that.
Any more questions for our professionals from the board? Next, we'll open to the public for comments, general questions. May I have a motion to open to the public?
Second.
So moved.
All in favor?
Aye.
Open to the public for questions from the public? Yeah, and comments.
And Mr. Wolf, do you recognize that you're still sworn from last meeting?
I do, thank you.
Okay, thank you.
Good evening.
Evening.
I think my presentation will answer some of the questions that were posed by the board. I also will preface it by saying that I don't agree with our planner's reading of the ordinance. I think he looked over or omitted to address a few key provisions in the ordinance. Oh, sorry, old age. I know, they look goofy, but they work. Section 9291 provides that residential lots in the Amwell Valley Agricultural District must be at least 10 acres. That was challenged in court, and East Amwell prevailed. This is something that's critically important to East Amwell Township. This ordinance is why East Amwell Township is not Raritan Township, and is rural and has beautiful scenic vistas. And so I think it's critically important that we adhere to this ordinance. There are 3 limited exceptions to this 10-acre minimum. Each provides some flexibility while at the same time preserving the density component and encouraging preservation of farmland. The applicant focuses on 2 of the exceptions, Section 9292 and Section 9291H2A. The applicant's planner, in his July 15th letter to Emily Deadweiler, attempts to shoehorn his client into these 2 exceptions by selectively quoting from the exceptions and ignoring the provisions of the exceptions that are contrary to his client's position. I'll explain why neither 9292 nor Section 9291H2A applies to the applicant's situation. I'll start with Section 9292. This provision allows a person who owns 50 acres or more to carve out 2 lots between 1.5 and 3 acres from the 50 acres, provided that the owner deed restricts the remaining portion of the tract to agricultural purposes. Essentially, this exception to the 10-acre minimum is designed to allow a person, often a farmer, who owns at least 50 acres of farmland to carve out from that land 2 home sites, typically for themselves and or their children, without having to make those 2 home sites at least 10 acres. In other words, it allows the 2 home sites without eating up 20 acres of farmland. The 2 home sites would only total 3 to 6 acres. As I mentioned a moment ago, to qualify for this exception, the owner must deed restrict the entire property, other than the 2 home sites, to use for agricultural purposes. Agricultural purposes is defined as the use of deed-restricted lands for common farm site activities, including but not limited to production, harvesting, storage, grading, packaging, processing, and the wholesale and retail marketing of crops, plants, animals, and other related commodities, and the use and application of techniques and methods of soil preparation and management, fertilization, weed, disease, and pest control, disposal of farm waste, irrigation, drainage, and water management and grazing. Basically, agricultural purposes means what you think it would mean, real traditional farming. Setting to the side that the applicant no longer owns a 50-acre parcel and is trying to turn back the clock, the applicant does not qualify under 9292 for the following reasons. First, the parcel that Mr. Zimmerman conveyed to Hunterdon County, which is the lion's share of the original parcel, was not deed restricted to agricultural purposes, which is one of the mandates of 9292. In fact, the parcel is not utilized for agricultural purposes. Rather, as the county stated in its application in 2005, the county uses the parcel, quote unquote, as the South County Park for recreational purposes. That's precisely why the county could not and did not use 9292 and had to seek a variance from East Amwell. I'll note also that best I can tell, this parcel wasn't deed restricted at all. And so I'm not aware of anything that would actually prevent the county from putting houses on this parcel if it wanted to. If it decided it no longer wanted to use the property as the South County Park, I don't find anything that says that parcel is deed restricted. Second, 2 lots have already been subdivided from the original parcel. In 2006, Mr. Zimmerman divided his remaining parcel into 2 lots. He kept one and presumably sold the other. Accordingly, contrary to the assertions in the applicant's planner's July 15th letter, the applicant doesn't satisfy the requirements of 9292. Now I'll address 9291H2A, which is the provision that our planner was just discussing. The applicant is also trying to shoehorn themselves into this provision. Section 9291H2A states the following, and I quote, "This option or zoning alternative is provided to promote larger parcels for agricultural uses and to encourage and promote flexibility, economy, and environmental soundness in the subdivision layout and design." So in other words, the purpose of this exception is to promote agricultural uses, which I defined earlier. Section 9291H2A applies to parcels that under the 10-acre minimum zoning could be subdivided into 2 or more parcels. In other words, it applies to parcels that are at least 20 acres. I'll call those subdividable parcels. 9291H2A provides that if you own a subdividable parcel that is utilized for agricultural purposes and you wanted to subdivide it for homes, you can create lots as small as 1.5 acres, but you can't create more lots than your total acreage divided by 10. For example, assume you own a 50-acre farm. Our general zoning rule, which I read earlier, would allow you to subdivide it into 5 lots of 10 acres each. However, to encourage the preservation of farmland for agricultural uses, Section 9291H2A not only allows, but also encourages you to create 4 lots that are less than 10 acres, as small as 1.5 acres, and leave the remaining parcel for agricultural uses. Thus, the owner of the 50 acres can create 5 parcels, 4 of them being 1.5 acres, and the 5th being 44 acres. The 44-acre parcel would then continue to be used for agricultural purposes, thus promoting our objective of agriculture. East Amwell viewed this alternative as a way to preserve farmland. Forcing the owner of 50 acres to create 5 10-acre lots likely would have wiped out 50 acres of farmland. Allowing the owner to create 4 1.5-acre lots and leave a 44-acre lot would retain a 44-acre parcel that could be used for agricultural purposes. As I noted earlier, Section 9291H2A specifically states that its purpose is to promote larger parcels for agricultural uses. In furtherance of this objective, Section 9291H2A provides as one of its requirements, the 6th requirement the gentleman referred to earlier, the design of the development utilizing this option shall foster the following objectives: retention of large contiguous farmland areas. It then goes on to list other objectives: streamlined corridor and wetlands preservation, steep slope protection, etc. The applicant's planner in his July 15th letter claims without any explanation that this 6th requirement is satisfied by the applicant. It is not. The subdivision with the county did not preserve farmland for agricultural purposes. To the contrary, the county stated in its testimony that the applicant's parcel which was 56.475 acres, was currently being farmed, and that the transaction with the county would result in 47.15 acres of that 56-acre parcel being converted from farmland that was being used for agricultural purposes to the South County Park. That's precisely why the county couldn't rely on 9291H2A and had to seek a variance. Section 9291H2A also provides that all lots created under this subdivision option shall be deed restricted against further subdivision. That's another reason why the county couldn't rely on Section 9291H2A. The lots created under the 2005 subdivision were not deed restricted against further subdivision. Moreover, and perhaps most importantly, the applicant no longer owns a subdividable parcel. The applicant's parcel is 12 acres. You can't divide 12 acres because 12 divided by 10 is 1.2. To subdivide under 9291H2A, you need at least 20 acres.
Mr. Wolf, can I ask where that's at in the ordinance?
Pardon?
The 20-acre requirement, where is that exactly in the ordinance?
In order for you to subdivide a parcel under our general rule, 9291H or 9291 requires you to have 10-acre minimum. So to subdivide, you need 20 acres.
See, I don't read it that way.
Well, it says it very clearly.
It says it if you like extrapolate on it, but there's no direct language.
Yeah,
that says
so
you need a
I
20
think-
acre.
Well, you don't have to extrapolate because when you read one of the requirements of 9192H2A.
I understand what you're saying.
Yeah, I understand what you're saying too.
It may be true, but it's
I
not
do.
sweeping.
But I just want to make clear, because I want to make sure the board is aware that what we're bound to is, and what the applicant's seeking is Section H, 2A, and then the 6 requirements. And if they're able to establish those 6 requirements, then they're entitled to relief, right?
Right, but
So I
that-
just want to make sure that's what everyone knows, where it's not per se the 20 required, but I just want to make sure they're clear with that we're reading some language in that isn't actually written there.
Well, I'm not sure that you're reading anything in, because when you read the requirement, and I don't have the provision in front of me, but if you...
20 acres anywhere here.
No, what it does say,
There's a density, there's a lot area, there's
it
suitability
says maximum
requirements.
dwelling unit density shall be 0.01 unit per acre.
And
That's
that
the
is
second
not-
requirement.
Yeah.
Not a minimum lot area.
But that's not a lot.
No,
yeah.
no, but in order to build 2 houses, you would need 20 acres, because the density is 0.01. In order to build 2 houses, when you do the math, you have to have 20 acres.
I understand, and what I'm
There's
saying.
nothing to extrapolate, it's clear.
But what I'm saying is that then would be a reason that the board could vote to deny it, right? Because then they would need a D5 variance, right?
Well, then you and
If
I are
they
in
felt
agreement
that.
on that point.
Yeah, so
Okay.
that's what I'm just saying. I just want to make clear that 20 is not in the actual language of the ordinance.
No, it's
Okay?
not. It doesn't
That's all.
say you need, you're correct. The ordinance
Okay.
doesn't
I just
say you
wanna
need
make
a
sure.
minimum of 20. When you do the math on the
understand.
0.01, you have to have 20,
I understand.
because to take 2 houses, when you divide 2 by 0.01, you
I
get
know.
20, which means to have 2 houses, you need a minimum of 20
I know.
acres.
I just want to make sure that the record's clear that there is no requirement per se in this section other than the mathematical side of it.
Okay.
of
but
that number.
The math is a requirement in this section.
Okay, well, I just want to make clear, the board knows the standard that they're judging this against tonight, that's all. Go ahead.
I have no use in this world whatsoever, other than I'm reasonably good with math. That's the only use I have in this world.
Okay, go ahead.
Okay. Okay. All right, so I have to pick it, let me see where, okay. So the applicant attempts to skirt these terminal infirmities by claiming that because once upon a time his 12-acre parcel was part of a 56-acre parcel, we should treat him as though he still owns the 56-acre parcel. Given that once upon a time East Amwell was comprised of only a handful of large parcel, buying into the applicant's turn-back time argument would open the door to development by others in East Amwell who own more than 3 but less than 20 acres. That would be flatly contrary to our 10-acre zoning. And even if you turn back the clock to 2005, for the reasons discussed above, the applicant's proposed subdivision doesn't qualify under 9292 or section 9291H2A. Accordingly, this board must reject the applicant's application. That's all I have. Thank you.
Thank you.
Anyone have
Thank
any
you.
questions for Mr. Wolf?
Thank you.
Thank you.
And anyone else from the public? Go ahead.
Pardon me while I move over.
I swear.
Mhm.
You need to be sworn. And you need-
Francis, I don't remember if you were sworn in last time, so I will swear you in this time, okay?
I swear to tell the truth, the whole truth, and nothing but the truth.
Perfect, thank you.
So help you God.
Help me, Goddess.
I like that.
Recovering Catholic. Francis Gavigan. I'd like to raise the point of common sense and having dealt with the county, many of us in the past. It's an imperfect government and function. I think there's been a sufficient amount of testimony that while it wasn't perfected, I have no idea, Ms. Zimmerman, how old your father was when he was doing this deal with the county and his arm was being twisted with eminent domain for the sale of the property, that the distinction without a difference, that the intention would not persist beyond 3 years. You've certainly demonstrated that there's been enough hardship in your family. The Case family and properties are legendary in the area, and this is a bit of a unicorn piece of property. I would proffer that the fact that the land that was sold to be part of South County Park, where the 4-H fair will be this year, is at least tangentially an agricultural activity promoting farm use, farm products and things like that, as everybody's vegetables and hay and things like that will get done. I don't think that granting them a D5 variance for the size of the dwelling would create a precipitating weakness in the ordinance throughout the township, because again,
Francis, just
yes.
for the record, they're not here asking for a variance.
No, they're not here, but should you decide that you're not going with what was 25 years ago or whatever, that they would need to consider just the 12 point whatever, I don't think that that would be such an onerous burden or gut the zoning, which I, like everyone else, is concerned about protecting. The individuals made a deal. They probably made it naively and with not necessarily the best legal guidance, but that finds us here with older property owners who are not going to be farming continuously, and Mr. Mattis at least has an intention to farm the adjacent acreage owned by the county, and perhaps on another tract separate from the planning board, the township could reach out to the county to clarify the future uses and lack of it becoming a condo development or something like that, should they not continue with the South County Park. To cut to the chase, cut these people some slack. They've had enough bad luck. They're trying to make this man's been trying to do this for 5 years, and it's not that big a stretch. And hopefully he would be a good neighbor, a good farmer, taking over from the older generation. Thank you.
Thank you. Thanks.
Anyone else have, from the public? I move. Seeing no one, I have a motion?
Second.
All in favor?
Aye.
Okay, we're closed to the public.
Mr. Mattis, do you have anything to conclude before I give the standard and give some guidance and allow the board to discuss?
Well, the only thing I can add is, what she had just said, that the Case family has now gotten older, and I intend to try to bring back the remaining portion to somewhat of a farming, piece of property. I have 3 kids. They have interest. I want to see if it turns into something. That's all I can say.
I have a question. Do you know what exhibit this is? What number this is? Oh, this is map 3.
That's
I have it, A2.
A2. Mr. Mattis, on, I don't know if you remember, last week you gave us an exhibit. It's called, it's A2, referred to as A2.
Okay.
Do you recall that exhibit?
I believe it was the first concept map.
This one looks like some survey.
So that was the,
Can you tell me where yeah, I'd like to know where this came from.
this one here
Yeah.
is the original county concept. This was the one that they were trying to say was 92/94. That
So-
was where they were originally trying to do 50 acres.
So it says proposed taking area,
Mhm.
approximately 50 plus acres, plus or minus?
Correct.
Okay.
Correct. That was, I guess, there was a lot of documentation. And then they finally got to, well, we flipped the board, the one that they submitted that was approved for the 2 undersized lots.
Okay.
But
Just
that-
wanted
that
to
one
understand where that came from.
That was the original one prior to the one that the county actually submitted.
Okay, thank you. Anyone else have any questions of Mr. Mattis? Before we? Okay. Testimony is complete. Ms. Smith, do you want to summarize?
Yeah.
And maybe our professionals can summarize, and then the board will have a conversation.
Yeah, so the application has evolved a lot since it originally came before the board. At this point, it's simply a minor subdivision under section 92-91. There is no variance relief. Everything has been worked out. So it is just a minor subdivision at this point. The applicant has changed since earlier on in the application process, and it is under section 92-91, the lot size averaging option. There are 6 items that have to be satisfied in order for the board to grant this type of relief. So one of which, and I know our planner Mike has talked about this, the minimum residential lot area is 1.5 acres. The maximum dwelling unit density shall be 0.1 acre per unit. Each lot created by the subdivision will have to satisfy the lot suitability requirements. All lots created under the subdivision option shall be deed restricted against further subdivision. The applicant is strongly encouraged to submit a concept plan of the lot size averaging plan to the planning board for review and comment in accordance with section 92-91H3 of this chapter. And finally, the design of the development utilizing this option shall foster the following objectives: retention of large contiguous farmlands, stream corridor and wetland preservation, steep slope protection, overall site design, reduction of impervious coverage, reduction of the amount of non-point source pollution entering the surface and groundwaters, traffic circulation, and the site's natural features, topography, and relationship to the open lands on neighboring parcels. When we're talking about a minor subdivision, this is different than a lot of the applications we have. A lot of times there's some sort of variance relief requested, right, where we talk about the positive and negative criteria. That's not at issue tonight. What's at issue tonight are the 6 items that I just listed. In order for the board to grant a minor subdivision, an applicant is generally entitled to subdivision approval if they meet the subdivision and zoning requirements, subject to any variance and waivers, which we don't have applicable here tonight. So it seems like from the testimony that we've had and the questions we've had so far, that really comes down to one issue we have and one particular item in that list. And it's whether or not we consider the huge parcel when we're talking about the density, the 0.1 density, or we're talking about the parcel as it currently exists. Now, the ordinance does not give any guidance on how it should be applied and what should be applied, right? So as Mike testified earlier, if it were the 62 acres to be considered, if that's how the board would like to read the ordinance to be considered tonight, then they would satisfy that requirement.
So is it your legal opinion that we could consider any other tracts owned by other individuals as part of this calculation?
So the ownership, I don't know if it's particularly important to the way the ordinance is written, right? If you read the ordinance, it doesn't say how you break that big number down.
Well,
Right, because we're talking about the concept plan too. Right, go ahead.
But an applicant only comes with their parcels to ask for averaging. They don't come, like, I couldn't file an application and use Mr. Catanacci's
No, I don't.
property, right?
I don't disagree with that.
So ownership seems to be significant because I can't make an application for property that I don't own, right?
But ownership at one point all was under one, and that's what I'm trying to say, is that at least on that, and that's at least the applicant's position, is that's how it should be considered. I'm not saying that's the right way to go about it. I'm not saying that. I'm saying it's up to the board to consider here based on the evidence and how they want to perceive the ordinance as written.
Okay, I was just concerned when you seemed to suggest that ownership didn't matter, because
I'm
that's
not,
how
ownership as in, the way the applicant's perceiving it is ownership at that point in time when it was 62 acres, it was all under one ownership, right? That ownership. If they're going to be considering that, if that's how you're going to take that number and extrapolate that.
I know, but in 2006, this applicant didn't own it. So I'll just take it as if you're saying that we can interpret what the ordinance means, I'll just go from there. But I just want to make sure you weren't saying as your legal opinion that we could not consider who owns the properties that are being asked.
I think that is a fair consideration, but I don't know if that, the way the applicant is presenting it is that it should be considered that way. And I'm not saying that's my legal opinion. I'm saying that's how they're interpreting the ordinance, right? The
So
62 acres.
I understand
And I'm
your
not saying that that's not relevant from the discussion that we have, right? That's not what I'm saying. What I'm saying is that's how they're interpreting it, and that's one way to look at it. I'm not saying that's right or that's wrong. That's going to be
I
for the board to
understand your
decide.
position. I was trying to understand what you were giving guidance.
The other way is to look at it is as the parcel currently exists right now, right? Which is the parcel currently exists right now. It's 12 point some acres, right? And if that is how we're going to consider it, then in order to get to that density, it would fail and it would need a D5 variance, right? In order to satisfy that. In order to do that, the board does not have jurisdiction to grant a use variance right now because you're sitting as a planning board.
It's not before us.
So it's not for the board to consider. Okay?
Thank you.
And that's all I have.
Can you just further explain the latches that this memo has?
Yeah, so they're as the mayor brought up the last meeting, there's a doctrine in the law, the equitable doctrine, it's called latches. Latches is generally applied when there is no statute of limitations, but there is a belief that, for lack of a better phrase, the applicant or the plaintiff or whoever it may be slept on their rights. They waited too long to do something. So at least in land use, in the research I conducted, it wasn't particularly illuminating. But could it conceivably be applied? Yeah, in a situation where the ordinance allows you to do it, right? So in the example that's given is if the ordinance gives something like a reasonable amount of time, right? You have to do something in a reasonable amount of time. That's where the board can make a decision that, okay, applicant slept on their rights, this isn't a reasonable amount of time. So that doesn't seem present here, at least in this ordinance for tonight.
Well, but don't you also have to apply it with the arguments being presented by the applicant, right? Because it's, as you said, we have to evaluate the argument presented and the ordinance together, right?
Yeah.
So are you saying that if we were to consider this, going back to the original parcel, then?
Well, not the original, but an earlier version.
An earlier version of the parcel. Yeah, original. How far back is the original?
Yeah, exactly.
Good point. I think one of the planners said it was, when did this start? 1990 or something? Yeah. If we were to consider the original, the 50 or 60 acres, then you're then saying if then you would saying, are you saying that then did they act fast enough?
Yeah,
Okay.
I'm saying,
just asking you.
yeah, I'm saying as a procedure, it would seem that if an applicant is making an argument that this body should cognize an agreement, an informal agreement, an understanding of something from years ago, that it would seem appropriate that timeliness is a consideration in whether that was fulfilled, to the extent that that's their argument, that that's was some kind of binding agreement.
Yeah, and I think, Mayor, that would be appropriate for the consideration if you're thinking of the applicant's argument that it should be the large acre or large plot, right? And, you know, from at least their argument is that it should be the large lot because, and I don't mean to put words in their mouth, but how would I have at least extrapolated from their argument, it should be the large lot because the county saw it this way. No, I'm not saying that's the right interpretation. I'm just saying that's at least what the applicant seems to present, right? But yeah, so if you, that would be a reason to maybe consider the lot as it says today, as opposed to the large 60-acre lot that the applicant is arguing would work.
Thank you.
Anything more? I guess give the board, individual board members an opportunity to ask questions of each other, to summarize where your brain is, questions that are outstanding for you. I'm going to not say who has to go first. I'm going to let people choose, unless, if there's someone who wants to speak first. Go ahead, Mr. Kadri.
So we have an applicant who wants to buy this property and farm the land and restore an old barn. And we have the opportunity and the flexibility to grant this request. And I think the really specific particulars in this case would seemingly preclude it from being used as a precedent. And the spirit, it's like, to me, it's whether you're looking at the spirit of the agreement that the current owners had with the county back in the day versus a real narrow interpretation of where the letter of the law might fall in contemporary, I mean, whether or not it's a D5 ordinance or the lot size averaging, I think it is being used as agricultural purposes. We had somebody testify under oath that they're cutting hay for the 4-H fair on that parcel now. I don't think it's realistic to think that the county's gonna put condos on this property. The spirit of the agreement was that they were going to be able to have this subdivision, and I think we ought to allow it.
Thank you. Ms. Wiggum?
The question for me has always been, how long does this agreement, and it's not just with the county. We have East Amwell's Planning and Zoning Board here that approved another lot coming out of this when the deal was made. So the question to me has always been, does that agreement from 2006 still hold today in 2024? I have not seen anything that contradicts that, that says there's a strict time limit, that it should be cut. In fact, we have heard many reasons why it didn't happen. But the set of mind that came out of the approval from East Amwell has stayed, and it was believed that that was still good. And I think, in my opinion, we need to honor that initial approval. It was made with the intention of giving this land or selling this land to the county for what I consider an agricultural use, because the fair is there and they cut hay on it, and as Jamal said, it's unlikely that they will turn it into condos. I think there's some restrictions that we have to make sure that everything the engineer talks about is done, that it's deed restricted at this point, so that there will be no further subdivisions. And I don't think it represents a precedent for other people to go back and say, hey, 20 years ago, I had 60 acres and now I have 12. This was an agreement. This came before the board. It came before the county. There was a lot that was going on at that time, and I have not seen anything that time limits that.
Well, so let me just ask you a question about your lesson, Candy. So you don't think that when there was a reference in the 2006 resolution that said there was an informal agreement between the county and the then applicant, and the then applicant will next year come back if he wants to make an application, you don't find that as a time limit?
I do not.
Okay. Well, that explains that. Okay.
Yeah, and the whole, going back to the informal agreement, again, I'm not an attorney by any means, but I mean, does that hold up in court if this goes, if this ever went to court? You know, there's an informal agreement, what was stated, we have no proof, you know, the burden's on the applicant to provide that information. So I don't know about that, but again, it's been 18 years, and I understand what you guys were saying, I totally do, and, you know, I sympathize, but that's just a long time before people start moving. And I also think it should be a D5 variance, the way I'm reading things. That's my opinion.
I mean, Jamal, on your argument that this is just a narrow issue and that we should promote farming, I totally agree about promoting farming. My concern in not seeing it as narrow is I'm very concerned as to how we apply lot size averaging, because some of the arguments and discussions I've heard seem very scary to me. That, for example, at any time, someone can go back into the past and say, well, at some point this parcel was larger.
And we
so,
deny that. I mean, I just think that's totally unrealistic.
Well, wait a second. What would you deny? So you would.
An applicant's going to come back to us and say that in the original trust of land,
Yep.
I'm going to go back to some. Right. I just think that that's not
So-
likely
so
to
why-
prevail.
So can I
Well,
ask you a question?
so then why would you go back 18 years here if you wouldn't go back at a further point? Is
Because
there like a cutoff?
this was a specific agreement with a family who's here today that was told that they would get this subdivision in exchange for giving up a larger parcel. We're not talking
That's,
about.
that's not exactly what it says. I mean, I know that's the spin on it. There was no agreement with the municipality, which is the only entity that has authority. There was a discussion, and even the documents say an informal agreement. Why do they call it informal? Because it wasn't formal, right?
We're parsing
we're not.
verbiage, and
No, we're
it's
not.
clear that the municipality
Said
acknowledged the
that you may
agreement that
come
the
back-
county had.
That you may come back in a year, which they didn't. So
Well, they told you why they didn't. They didn't want to have a perk test that was only going to be good for 3 years, and they had other things on their plate.
So will every applicant be able to put off their obligations?
What
if
I'm
they have
saying
a
is,
family
there's
thing?
no other applicant I can foresee coming before this board and steamrolling some lot size averaging based on.
Lot size average.
It's not. It's a very.
See, that's
it's
the
very
problem.
specific. It's
Mr.
like
Mayor,
Francis said. This is a unicorn.
Does the fact that there is ample evidence, whether it's legally binding or not, but there's ample evidence that, you know, there were conversations with the county, that the county was creating a document that says proposed taking area, which to me shows, it doesn't say proposed purchase, proposed taking area. We've heard testimony that there's eminent, that they were talking about bringing, you know, using eminent domain. So to me, that started something rolling, right? And now we have evidence that may not be legally binding. I will, but we do have evidence that there was an intention from the county that East Amwell never raised their hand and said, hell no, right? They didn't say that.
Well,
They
it doesn't have an ability to say hell no. So let's go to that example.
I'm
So
just-
in the example that you're giving,
I'm
you're.
just trying to,
No, I'm trying to respond to it. So in your example, a property owner sells property for consideration,
yes.
right? And then wants to subsequently lot average because they
This
sold.
was a consideration
No,
of the
hold on,
sale.
Hold on, hang on. I'm answering her question, then you
Yeah.
can jump in. Right? So in terms of the question of a deal with the county, an agreement with the county, my concern, again, because my biggest concern is, look, I really empathize with this individual who's come and he wants to farm and he wants to do something, but my concern is if we apply lot size averaging in the way that I think some folks are contemplating, I think it just opens the floodgates. I know you disagree, Jamal, but here's the example. So query, can someone with a 100-acre parcel sell off most of it, get the money, and then come into us and say, I want to now do some things and have variances in lot size average my remaining lots, and I want you to consider the parcel that I sold as part of that.
No,
Now-
because they did not come in with there was no discussion about what they were gonna do with all of the land when they sold that. They did not, nobody.
Sure there was. It
Nobody
was-
came in with a preliminary plan. If they,
Yeah, it was 62 acres.
But they did come in
Was
with-
to be sold, and the concept was that they would get 2 lots, right? So, sure, it was contemplated, but
they're
again,
two
when
different-
you,
Those are two different situations. Somebody
They're not.
selling off and then coming in versus somebody selling off and
my
having a
point
discussion.
is,
I'm just-
I shouldn't be able to sell off land and then use it again to lot size average.
But
If-
that's a hypothetical that doesn't fit this case
I
at
think-
all.
I think
That's
that
what
is
I'm
this
saying. I
case.
don't- I don't-
No,
This was
because
part of the
this
sale.
was part of the sale. It was part and parcel of that
So
agreement.
why do they get to now lot average it again?
Because it was anticipated at the initial sale.
No, it said next year they will do a test, and if it passes, they may come back and ask for one another
Again,
lot.
I think that is a narrow interpretation of some interpretation of the letter of the law, when the
I'm
spirit of the agreement was that they were going to be able to subdivide as part of the sale.
Forever.
You
At
know,
any time.
it's like it doesn't give a lot of confidence in local government if it's the municipality or the county. If folks make an agreement like this,
There was
and
no
then,
agreement.
and then there
No,
was an agreement.
Look in the resolution. It does not say in the resolution, which
You know,
is the only
it's
agreement.
because somebody wasn't precise enough to capture
No,
that.
they captured it precisely as an informal understanding between a third party. So look, I won't be able to convince you, but my point is, I don't think the way we're looking at this, we have many reasonable protections on applying lot size averaging. Because I know you don't think it'll come up, Jamal, but I could see cases where it certainly could.
I can't
Because
see this board approving it.
Well, really? We're seemingly approving this, right? So,
By very specific circumstances.
every time an applicant comes, there's gonna be a specific circumstance with a specific family issue and everything, right? That's not for us. For us is, are we applying our ordinances in a way that is reasonable and fair and looks at the big picture? Because
And
if we
legal.
don't do that, then why have government?
I'm all for reasonable and fair.
Agreed.
And legal.
Yep.
Excuse
Well,
me.
aren't we also supposed to be promoting farmland too? If he puts his house on a property, I agree it's gonna take some farmland space up there, but his whole purpose is to farm on this property.
Well, it's being farmed now, isn't it? Right?
yeah, it's being
It's
farmed
eligible
now.
for farming. The only thing this will do is it'll allow another residence to be constructed.
I think
But it
that-
won't change the fact that this is land in the Amwell farming district, right, where you can farm.
I think you underestimate what it takes to restore an old barn and farm. That's like, it's like a farmer's heart is not something that's just going to come to vacant land because it's preserved.
I'm all for restoring barns, but the question for us is, are we following our ordinance that says we've got 10-acre zoning and we've got a very limited way where you can do something if your purpose is to create a large agricultural lot, right? That's the language of the ordinance we're using, right? So if when you do lot size averaging, you get to a place where you're preserving a large lot, then you're doing it. But here, we have 2 small lots, right? Or we got a 12 that's going to be proposed for 11 and 2 or something like that. That's not creating a large lot. Why? Because that was created 18 years ago, and
Well,
that's not this.
What I hear our attorney advise us is that we actually have the flexibility to approve this request if we see it as part of that historical agreement with a larger lot.
And that's why I say what you're saying, it's not narrow at all. It's very broad, because when I want to do a lot averaging with my property, I'm going to say, hey, John Ringo's used to own that, and it used to be 220 acres in 1800, and it's been divided now, and that should be counted. And it doesn't matter if I'm if I'm not the owner, because a previous owner had it. So the problem is just, in my opinion, that the way that I think you're looking at it, and Candy's looking at it, is it pulls at the heartstrings, so you want to do something good, which I understand. But if we do it in this way, it seems to me like we're not following the ordinance. The purpose of the lot averages is to take a large lot, have most of it saved, and then have a couple small things. That ship has sailed 18 years ago. We're now looking at two small lots, and now, then one that's being farmed wants a house on it.
I'll give you not a hypothetical, Jamal. I bought 30 acres from Bryce Thompson, and it's next to 100 acres, right? That is not preserved farmland. That's sitting in the valley, but it is a flag lot, a 100-acre flag lot. The Thompson Realty has been before this board, because I get notice, for years and years and years. They had every conceivable argument, just like we've heard from these folks, other than sympathy, since Bryce was is a rather large landowner, and he sold off all the parcels, and there's 100 acres. It's sitting in the middle of this valley, right? I have 30 acres, and I have 1,200 feet of road frontage, right? It's contiguous, so do I get the benefit of his 100 acres in terms of averaging, in terms of putting houses?
Totally different circumstances.
No, it's not it's the exact same circumstance. You don't want to listen. Listen, you say you want to, they're preserving things. They're not preserving anything. It is what it is. It's not a very pretty property, right? And if you've ever gone to see it, it's falling apart.
Let's
Yeah. Okay.
That's your characterization. Let's stick to the.
All right. Well, in any event, this is not a situation where somebody's spending lots of money to preserve barns and historical properties or anything like that. That there are case properties that were historical properties and have been purchased and are being restored. This is not one of them. There were many case properties. Don't forget, they own half of this area. But it's more than a slippery slope. We have an obligation under the law, right, to not to act out of sympathy, and we all sympathize. I mean, who doesn't sympathize with someone who has a child who is ill? But I mean, we didn't create this. The truth of the matter is that the same circumstances, you're talking about a child, a terribly injured child, enabled Bryce Thompson to buy the Johnson farm, when it was the 30 acres and the Johnson farm was 360 acres, and he was able to buy it very cheaply because their son was tragically injured in an automobile accident, and they needed money to save his life. All right, those things happen, but that doesn't mean that Bryce, that I now can basically avoid 10-acre.
I don't see those as the same at all. I see this as a family that made a deal with the government, and that deal, that part of it was a larger parcel, and they were going to get the subdivision as part of it. And I think those are really specific instances that are not at all replicated by people looking back at old ownership or adjacent private property and saying that they ought to be able to lot average that. I think those would be dead on arrival if people came here and presented it. And it's not about sympathy, it's just doing the right thing. The spirit of that agreement, I think, is pretty clear.
I'd like to take up the spirit of the ordinance here.
Yeah, thank you.
The spirit of the ordinance is that we're trying to preserve farmland and make sure that we have large swaths of contiguous farmland. And I think that there is a path to getting Mr. Mattis what he wants. It's a D5 variance. I mean, there's a way you can subdivide a 12.5 to 12.62 acre lot and have two homes on it. It's for the board for the zoning board to make that decision. I think that's a different, and again, I guess I'm working from the presumption that the agreement here is that the lot we're starting from is 12.62 acres, not 50, I don't remember what the number is.
62.
Yeah. But there is a path to giving Mr. Mattis what he wants. and Mr. Zimmerman what he wants, but it's through a D5, not through relaxing our ordinance.
See, I disagree that it's relaxing our
I do
ordinance.
too. It's like a more circuitous route.
Obviously not going to change your mind.
No.
This is one of those cases where I go back and forth and I go back and forth. And sometimes I really, 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 really dislike the law. I'm not saying anything about lawyers, I'm just saying.
Fair enough.
But
You probably could.
but it's, you know, it's written, it's fairly narrow, and if this had been, there's two things that kind of tip me. Number one is the fact that the property is not deed restricted, very much concerns me. I can foresee the township doing something. I absolutely can. And number two, this family was represented by attorneys at the time. And there was an opportunity there to do something, to perhaps write a tighter agreement. It is to me abundantly clear that that they were persuaded to sell. I'll use that word. They sold. I would expect it's market rate. And that started this process, and that they did have intentions of some sort, and that different people weighed in, different town, either municipality. But that is, none of that to me appears legally binding or defensible, unfortunately. I feel like I have to, like, this narrow reading is where I'm stuck, and I don't actually like it. Because it's not what, if I don't vote to approve, it's not what I want. I want to vote to approve, but I don't know if I can. That's kind of where I sit. And, you know, perhaps a variance would be possible, you know, could meet, I can't opine on that, but I did turn to someone and said, I wish this was a variance application at one point. I don't know whether that meets city criteria, I'm not saying that, but I'm just, I really struggle with this, though. That's, so it comes down to, I really hate this, and I'd like to fix the ordinance too.
Well, that was going to be my next thing to say, is that a lot of times in anyone who's involved in local government or politics, is a lot of times you don't realize there could be an issue with an ordinance until you come across it, right? So we're talking about whether the lot, what should be considered, right? We all have different interpretations sitting here, right? That's something that could be fixed, right? At what point in time is that starting point, right? There's an interpretation on the table from the applicant, there's an interpretation from some of the board members. These are things that happen, and this is the way the process shakes out. But I just want to remind the board that you are bound by the way the ordinance is written right now, right? We can't think about what we wished it said, but we need to make, how it's written right now is how you have to make your decision tonight.
So, it strikes me that might be an elegant solution. If you think that the current ordinance, as it's written, gives us the flexibility to approve this under lot size averaging, but we're concerned about precedents down the road allowing all kinds of people to come willy-nilly with lot size averaging requests, then we could approve the Mattis request and then tighten up that ordinance, just like we are with warehouses. So if we want to stop people from abusing a generous interpretation of lot size averaging, we could fix it subsequent to approving this request.
Yeah,
I think that's very facile, but it's not what the law is. You are bound by the ordinance as it exists now, not by an ordinance that you would
Right,
to approve.
but
You are bound by the ordinance as it exists now.
I understand that, but what I'm suggesting, you tell me if I'm wrong, is the ordinance as it's currently written gives us the flexibility to approve this request. So we can do that, and then if you want to tighten it up so that it's not abused down the road, we could tighten it up.
I think
I'm not
that
convinced.
your, excuse me, I think that your former mayor explained in exquisite detail, who happens to be a very fine lawyer, right, as well, in exquisite detail, right, exactly what the ordinance says and what it means. And I think that that may make you unhappy because you have this view, and apparently it's shared by others, that these people were somehow screwed by Hunterdon County, or government as you call it. That's not our problem. Our problem, it's not our duty to get to, it's not our duty to try to mangle, for lack of a better word, the law and the ordinances and 10-acre zoning and all of the things that people who have lived here for, like myself, for 40 years, to protect farmland, all right? And this does nothing for it but create an exception, and trust me, the exception will be, if it's granted, it will be jumped on by any number of people. And Jamal, you haven't lived here long enough to know that. And you can't, and you,
Well, with due respect, these folks have lived here longer than you have, and they've been farming.
yes. And so have
Jamal,
I.
my problem is, when I say I don't like the way it's written, I don't see how we can interpret it broadly. It's I feel like it's very narrow. And I think it needs to be written, like, I feel like
All our
more clear
professionals-
so that we're not having this discussion of how we can interpret it.
All our professionals have given us guidance that we can interpret this broadly enough to approve it.
Yeah, but the problem with that is that's saying that we can look at it and decide what legal interpretation we give it. I'm not totally comfortable with that. But let me get back to where you are trying to build bridges, because I share that notion. I mean, I would think from just a procedural kind of a good government approach, it would be better, rather than do something and then try to fix it, I would say we should try to use the existing law, as, you know, maybe Matt and
Al.
Al,
You know,
thank you, and
Al is you.
Al have laid it out, where there is another route to go that could give relief, but it wouldn't be, in my opinion, at the risk of extending something which, as a lawyer, when I look at this and a member of the board, I don't think we can make it as broad as some folks are thinking we can and just choose to do an interpretation, because when folks do that on boards, it goes up to a court, and the court looks and says, that's just unreasonable, right? Because it's arbitrary and capricious, because you can't just give your own interpretation to it. And so
Who's going to challenge our approval of this? What court is
these
going to
happen all the
challenge this?
time.
Yeah.
Yeah, but
These-
what,
these
who's
happen-
going to contest it?
So I can say, right,
Yes.
there are, so any decision by a land use board can be challenged. So it can be, if you deny an application, it can be the applicant, right, who challenges it down. But if you grant an application, it can also be someone from the community, anyone who has an interest, right? So there is such a thing, and while it's more rare than denials, you can, it can be challenged, an approval can be challenged by
And I don't
members of the
want to,
community.
and I don't want to
who
lose
have
the
an
point, because
interest.
the basic point I was making was, I think there are existing legal ways that the relief might be approached. And look, this application has changed how many times since we started in April? It's morphed so many times. And I think if you're looking at, for appropriate ways of trying to do justice, which I know we're all doing, and I know you are in particular, right? That we use existing law to do it. I'm just very uncomfortable using lot averaging, because I don't think this is at all what's contemplated, the spirit, intent, or the express language. And so that's why I'm so uncomfortable about that as a device. If the application is changed, and it's, as these gentlemen were talking about, it's sometimes allowing a greater density where you can meet the other factors and do it, to me, that's a much more appropriate way of at least thinking about it. I'm not prejudging and saying that it should be granted, but to me, that's a better way to approaching it than to say, look, if you ever had a parcel that touched and concerned where you are, Dante, you can throw that into the mix. And if those guys on the planning board interpret it that way, you can do it. I just don't think that's the way to go.
Right.
Was the original application was for 1.5 and 10 or something like that, and the 1.5 was grandfathered, so they weren't trying to use lot?
So they were using the other section of the ordinance.
They weren't using lot
They weren't
averaging.
using lot averaging, no, that changed, that was at
The
the
lot
last
averaging is a
meeting.
new thing. They went away from the variance. And all I'm saying is, maybe variance is a more appropriate way to think about a parcel that's not trying to average something that no longer exists and is owned by somebody else, but rather, sometimes, variance is recognized that sometimes there are hardships and disadvantages and crazy things that happen, that if you can still be in keeping with the zoning ordinances, may be appropriate to do on a case-by-case basis. To me, that's much more what this pitch is about than saying, boy, averaging should be done in this broad way.
Right. And
That's just the way I think of it.
I don't know if anybody on the board knows what a D5 is, but if not, D5 variance is, this variance seeks approval to allow an increase in the permitted density and parens intensity of the property. An example is a 2-family home in a single-family residential district. So that's kind of it in a nutshell, which would seem, in my opinion, we need for this application.
Anyone else?
And just to go back, I mean, when I served for South Brunswick boards, yeah, there was a lot of court cases as well that, cost taxpayers and whatnot, a boatload of money. So people do get challenged. Not saying that this is going to happen, but it does happen often.
And people come in when they see that there's a potential loophole. I mean, this is why we spend so much time on the township committee and in this body trying to make sure our ordinances are squared away so that they say what we want them to say, because we want our residents to expect what we have in there. And that's why it's scary to me to be potentially creating loopholes. And people try to drive through them all the time. It's human nature.
I think it's time, I think with the board, do we agree we take a vote now?
I agree.
How do I want to, do we want to do this as a motion? I'd like to get the variances on, the conditions on the record.
Okay,
It's
so
not
yeah,
a-
I'll just, if the board is inclined to grant the relief that the applicant seeks, these would be the conditions of approval. Would be pursuant to the ordinance, they would have to deed restrict the lots against any further subdivision. In a previous hearing, the applicant agreed to deed restrict the existing single-family home, the existing property to a single-family use. The applicant would have to get all outside agency approvals as discussed in the board engineer's letter, and they would also have to have the plans reviewed for consistency with the board engineer pursuant to the map filing law.
Alexis, the applicant also had agreed to deed restrict it to farmland use in perpetuity when asked.
Is that something that the applicant would still be?
Well, I didn't hear that, I'm sorry.
When I asked Mr. Mattis at a previous meeting if he would agree to deed restrict this as farmland in perpetuity, he agreed that he would do that if this was granted.
If this was granted, I would.
So that would be, so you agree that that would be a condition? Okay. And that would, so those would be the
With a
5.
house on it, but the rest being farmland, is that what you're saying?
Well, yeah, I guess however it would have to be stated.
But you would still build the house?
Yes.
Just wanted to, okay. So those would be the conditions. May I have a motion?
I move that we approve with these restrictions applied.
These conditions?
Conditions.
These conditions.
May I have a second?
Second.
Kristen, will you please take the roll call vote?
Gladly. Miss Wiggum?
No.
You did not approve. Okay.
Mr. Catanacci?
I'm sorry, but the motion is to approve?
To approve.
Nay.
So, no, yeah, no would be to deny the application,
Deny
for
the
clarity.
application. Thank you.
Mr. Kadri?
Yes.
Mr. McGovern?
No.
Mr. Nardi?
Yeah, I'm voting no. I think this needs a variance, and I also think, the 18 years is far too long, so my vote is no.
Mr. Kohut?
No, and I'll second what Al said.
Mayor DePiero?
No. Do you want to get the rest of the voting? I do want to put my reasons on the record. Tell me when.
You can state them now, or you can, it's however you'd like to do it procedurally.
Finish, yeah.
Yeah.
Okay. So let me say, I'm very empathetic, Mr. Madison's situation, and I support farming. I'm just not comfortable that you've been able to meet the criteria for lot size averaging, which I think needs to be applied in an appropriate way so that it meets the spirit and intent and the needs of our residents. Let me mention a couple of things. The applicant doesn't satisfy lot size averaging because the application does not promote larger parcels for agricultural uses. The town code provision, section 92-91 A2, provides an option for lot size averaging in the Amwell Valley Agricultural District in order to, quote, promote larger parcels for agricultural uses, end quote. This provision is not applicable to this application because this application would not create a larger parcel for agricultural use. Lot size averaging permitted by the ordinance, it would be something like if you have a 100-acre parcel that would be divided up into, say, 4 1.5-acre lots with houses on it, and the remaining 94 acres is a large agricultural lot, which would be farmed, and all the properties, the agricultural lot and the deeds and the individual lots would be deed restricted against further subdivision. Here, the application would take an existing 12-acre parcel that's already being farmed and allow an approximate 1-acre parcel to be cut off of it. That would reduce the size of the 11-acre parcel. The application is not creating larger agricultural parcel. It's actually reducing the size of an existing agricultural parcel. Moreover, the application would also allow construction of an additional house, which does not promote larger parcels for agricultural uses and would add impervious cover, even though there would be adjustments to remove other impervious cover. Therefore, for that reason, lot size averaging in the Amwell Valley Agricultural District is not permitted in this application. Second, lot size averaging doesn't apply because this application does not foster the required objectives of lot size averaging. Code provision 92-91H2A provides, quote, the design of the development utilizing this option shall foster the following objections: retention of large contiguous farmlands, stream corridor and wetland preservation, steep slope protection, overall site design, reduction in impervious coverage, reduction of the amount of non-point source pollution entering surface and groundwaters, traffic circulation, and the site's natural features, topography, and relationship to open lands on neighboring parcels. Unfortunately, this application does not foster those objectives. Retention of large contiguous farmlands, no, as I've indicated before. Streamland corridor and wetlands protection, no. Steep slope protection, not applicable. Overall site design, no. Reduction of impervious coverage, no. It would actually increase impervious on the lot we're talking about that would go to 11 acres and change. Traffic circulation, no. Reduction of non-point source pollution and in groundwaters, no. Site's natural features, topography, relationship to open lands on neighboring parcels, no. Third, lot size averaging does not apply here because the lots have already been adjusted multiple times in the past, and the large agricultural lot was already severed off years ago. The properties at issue in this application were at one point part of a 62.6 acre parcel. In 1999, 5.7 acres were subdivided off. In December of 2005, 47 acres were transferred to the county. This was a sale for consideration. This, in fact, was the change that created a larger agricultural lot. What that left was two smaller lots, approximately the size of what remains here today, although there was another subdivision in 2006 which again adjusted the lots. The bottom line under the ordinance is that the creation of a large agricultural lot was done in December 2005. that adjustment cannot be used as a rationale to assert that the existing 12-acre parcel is eligible for lot averaging now. The larger agricultural lot was already created. This application would actually decrease the size of the current agricultural lot. Moreover, lots simply cannot, under this ordinance, in my opinion, be adjusted over and over in circumstances like these. The ordinance's intent to create a larger agricultural parcel is simply not supported by the repeated adjustments over time. Moreover, the ordinance's requirement that lots be deed restricted against further subdivision further supports that conclusion. The ordinance, in addition, cannot allow the 62 acres to be included now and averaged because all land that used to be in the larger tracts back in time should not be considered. I mean, if that were what the law permitted, then, you know, all the land that King Charles gave when he gave all of New Jersey to his brother would now be lot averaged. In addition, a person simply can't sell a large tract of land and then expect to be able to use it to do lot size averaging on remaining lots. If you sell it, if you transfer it, it's simply not part of the current calculus and the current application of lot size averaging. To mean anything and to make any sense, lot size averaging has to be done at the time the application is made, because otherwise we're not creating large agricultural lots. We're simply allowing land to be readjusted over time and possibly ad infinitum. In addition, it's significant to me in applying the ordinance in the way that I think makes sense, and the only way it can make sense, that this applicant does not own the 62 acres and therefore can't use it in lot size averaging. It would make no sense to me at all if we interpreted our lot size averaging statute ordinance to say that I could average my lot with property owned by anybody else. To do that would defeat the purpose of taking a large lot that I have, encouraging me to lop off the largest portion and keep it in agriculture, which we support so much, and have a couple of smaller units that are smaller than the 10-acre individual lots, but for which I could have a couple houses for myself or my kids or relatives. Fourth, the 2006-20 Planning Board resolution does not provide a basis for approval of the application. We've gone through what that resolution provides. Essentially, it included a clause number 5 on page 2, and the resolution which stated, quote, "Next year, soil tests will be performed on the remaining acreage near Route 179, and assuming the soil tests are favorable, the applicant expects to return to apply for an additional building lot." And it's noted that that was an informal understanding between the landowner and Hunterdon County. But Clause 5 simply does not provide rights and does not bind this planning board. It's black letter law that resolutions by local land use boards do not have precedential effect for subsequent applications. Each application must establish the criteria in the applicable provision of the Township Code to obtain relief. Therefore, the resolution 2006-20, as a matter of law, does not bind this planning board in this application. Also, the avowedly, quote, "informal agreement," unquote, with Hunterdon County simply does not bind this planning board. In addition, the, quote, "informal agreement," unquote, was only, even if you look at its terms, if soil test results were favorable, the landowner expected, in quotes, to return to, quote, "apply for an additional building lot." That is not the language of a binding agreement. Finally, there's been some suggestion that we should consider a, quote, unquote, "concept plan" with the county. However, that's simply not binding. As we know, the county has no authority over land use matters and clearly has no authority to bind the township. If the township intended to be bound, it would not say in a resolution, there's an informal agreement and someone expects to come and may ask for relief. If we enter into an agreement and that's memorialized in a resolution, it would say, we agree, this is what has to happen. If this happens, that happens. That's simply not the language of the agreement. Finally, there was suggestion that we should consider the fact that a 25-foot easement was created in 2006, just after the planning board resolution. However, the creation of such an easement in 2006, when a subdivision was approved, simply in my mind does not create the right to a new subdivision approval at this time. That was something apparently that was part of that application, and that application has been resolved years ago. It's simply not, I think, an existing right for anybody, including the applicant. Fifth and finally, under the doctrine of latches, even if the landowner had any rights, the landowner is precluded from getting relief due to the 18-year delay in exercising that right. Latches is an important doctrine because it precludes relief when there is an inexcusable delay in exercising a right, and especially when that causes prejudice, and that's what we're talking about here. Here, the landowner did not take action for 18 years since that December 2006 resolution, and the effect of that is it precludes getting relief that he claims he may have had under the resolution to do a soil test the following year and perhaps apply for an additional building lot. The time frame also specified in Resolution 2006-20 ordinance did, in my mind, establish a clear time frame for which, if there was going to be a return for a potential application, the language clearly is next year, and that is the time limit. And even if applicant had come back sometime after that, I think no one would have precluded them from filing an application then. However, that time frame has long expired, and any rights that an applicant may have had back then have been forfeited under the doctrine of latches. Under the law, there was, in fact, a sufficient opportunity to exercise rights over the past 18 years, and that simply wasn't done for the various reasons that were testified to. There was a choice not to do it. I understand that there may be a family circumstances involved, and our heart does go out to folks as a result of that. However, we have to be mindful in making sure that our agreements are clear and precise so that there are no unfair expectations, and things that are required by law are in fact followed. Here, the only way to look at this, I think, fairly is that the rights were slept on, and the township is entitled to reasonably rely in good faith on an abandonment of rights, because I think that is what happened. And I know a new subsequent purchaser wants to come in and use the land, but that's and is being, I think, bound by actions of a previous landowner. But I think that's because that's the argument that this landowner is making in the application, that they would like us to rely on that. And I think that just unfortunately can't be justified under this doctrine. So I think it's really important that we do our best to interpret lot size averaging in the way which it's intended and ought to be interpreted in our town. There may be other forms of relief like we talked about, and that may provide a basis, especially variance type relief, because variance relief is for hardships and strange types of land and strange situations that have happened. And to Jamal's point, there are things that don't reoccur, and it makes me much more confident knowing that there are those sorts of doctrines that can be sought rather than something like lot size averaging, which could put our treasured protection of our land and our 10-acre zoning at risk. So for those reasons, I have to vote no.
Okay. Hold on a second.
Yeah,
I
let's
haven't
go through the
voted yet.
motion.
Let's finish the voting.
Let's go through the motion.
Chairperson Deadweiler?
I vote no. And I think primarily because my reading of the law does not allow us to. It's not what I want to vote, it's what I'm required to vote. And I want to make that clear. So I think the motion did not pass.
Did everyone vote?
everyone voted?
Everyone has
Okay.
voted.
Yeah, so since the motion did not pass, the application is denied.
It's 7 to, it's
7 to 1.
7 to 1, thank you.
Yes.
Did I read this wrong?
I'm sorry.
Excuse me.
Mr. Mattis, the motion is
Mr.
denied,
Mr. Jamal, what are you doing?
the application is
I'm
denied.
asking,
Yeah, well,
I hear-
this is, well, ask it, let's hear it.
So at
Let's
this
do it.
point,
So at this point, let's just be
Let's
clear.
through the
move on.
chair.
Let's move on.
Yeah.
We're moving on.
Or if you wanna-
Yes, we're
if
gonna
you
take a
wanna
5-minute
put your
recess.
dissent,
May I have a motion for a 5-minute
moved.
recess?
Second.
Second, all in
Aye.
favor? Aye. Okay, we will have a 5-minute recess. We will be back at 9, actually, we'll take it to 9:25. Let me see where we are.
All right, now I'll
Okay,
go.
next thing, okay, we have Monahan, which is continued to September 16th, 2024. We have no new business. Invoices for approval. Has everyone had a chance to see the invoices?
Yes.
May I have a motion to approve the, all of the invoices here?
I so move.
A second? All in favor?
Aye.
Okay, invoices are approved. Now, if you'll indulge me, we've been discussing ordinance changes for a while, and I've always found it really hard when an ordinance comes up and we're asked to vote, or we're asked to opine on it, and it's already in ordinance form. I'm not a lawyer, I want a memo of understanding first. I want to understand what we're doing. So I'm gonna try doing that with a couple ordinances that we've been discussing, areas that we wanted to change. So the first one that we wanted to look at is the historic preservation ordinance. And for that, I'm actually gonna ask Tamlee to come up and help guide us through this, because she has been working on this with the Historic Preservation Committee and has some background on this. But I will first say that there's a document in your folders that I know Tam has. I'm the author of that, so I'm not gonna blame it on Tam. And the reason I say that is because it's not meant to be an ordinance. It's not meant to be in legal form. It's basically supposed to be a preamble.
Excuse me.
God, not sure. Did you lose it?
But I didn't get, I didn't
I
get.
lost mine, so.
Oh, are you good?
I just- I'm just-
You did feel it. I'm like, did you print one of them? So I don't
Little
expect.
six fingers, Jamal.
It was, no, it's good. But you know what, I'm gonna talk us through it, so
Oh, it's on my phone?
it's
so
in your,
my-
it's in your.
on your
yeah.
phone. It
But I
should
will,
be on your.
we will talk you through it. So basically, you know, I think we all know that there's quite a bit of history in East Amwell, and we all agree we want to preserve that. Going back, at least to the 90s, there's been work done on that. And particularly, and if you go back and you look at our master plan, it's every time they do a re-exam, they say, you need to work on, you need to continue this process. And particularly, we have a historic preservation committee, but what we don't have is a good means to actually protect the properties, right? And we actually are lucky in that in the 80s and the 90s, there are some wonderful people whose names I don't know, that Tam does know, actually went and got, seven different properties and areas put on the National Register of Historic Places. So the next step of that is, okay, we have all these properties, we have this goal, what is our next step? And this is where I want to ask Tam to talk us through sort of things that we've discussed before, but this is what we're proposing to do, and if the board is amenable to this, we will move, I want to get some back and forth on this, and then the next step would be to draft an ordinance. So if you want to add something to that, what sort of you were proposing?
Sure. So the way this process got started is I heard, people talking, including our mayor, that, the historical preservation is important. And so I looked at the ordinance to see what we could do to make it a little bit more effective. And another impetus for this was just watching planning boards and seeing applications where people are proposing things in some of these historic districts that Emily talked about. And the board currently has no authority to consider the architectural design of any of the buildings in historic districts, which could potentially compromise the historic character of those districts. So I took a first stab at modifying our existing ordinance to make it a little bit more
So,
effective.
Tam, I have not given them the ordinance. I just want to talk about what we're trying to do.
Oh, they don't have
No,
this?
because I don't want to go there first. I want to say, what are the
Okay.
changes that we're going to make?
Okay.
And get sort of agreement, and then we'll have the ordinance in a week.
I apologize. There were 2 ordinances that were forwarded.
They were not
They were not ordinances.
They were not. They were not ordinances. They-
Oh, yeah.
Discussion.
That's where, they were discussions.
Outlines.
Yeah.
Thank you.
Okay, all right. So, the objective of the proposed changes that you hopefully will review sometime soon, are to take the historic districts that we have, which are currently national historic districts, and make those local historic districts. Because a national historic district, I think I've mentioned this before, it really doesn't do anything from a local standpoint. It doesn't give you guys any ability to assume that things are historic, because there is no local historic designation on that. The only thing a national historic designation does is if somebody's using federal money, then it has to go through the federal historic preservation process. But that's rarely the case here. So it would add architectural guidelines, not standards, because the consensus was that, at least with the people I was working with, that standards are a little too strict. We prefer our ordinance to be a little softer and have some room there. But at least with guidelines, the planning board could consider those guidelines when they're reviewing applications. Another thing that this would do is actually, like I said, create the local districts, which would mirror the national districts with a local modification to that. This would also add some verbiage regarding demolitions. Right now there's, a historic building could be demolished, and it still could be. There's nothing in this that would, we can't stop somebody from demolishing a building. But what this change would do is it would defer that demolition permit, if someone got a demolition permit, for 30 days to allow the Historic Preservation Committee to at least go in and take photographs so that we have some sort of record of what was there. And then the last thing it does is it fixes some of the inconsistencies in the ordinance. So for instance, the way in most of our committees here, the members are appointed by the mayor. Historic Preservation Committee, that's not the case. It's the Township Committee. So we just made it consistent with virtually all of the committees. I think if this change goes through, there's only one more committee where the members are not appointed by the mayor. So we fixed inconsistencies like that. There are others as well.
I'm sorry, can you just clarify the point you just made about who appoints under the current situation and who would appoint under this change? I just didn't follow quite.
Okay, so every committee that we have here in town, there's an ordinance that establishes that committee.
Mm-hmm.
And those ordinances say how the members are put onto that committee.
Right.
And sometimes it says it's the mayor, sometimes it says it's the township committee, sometimes it says it's the mayor with the approval of the township, they're all different. Mm-hmm. So the idea was to bring this in line with the other ordinances for the other committees. And so the change was made to say the mayor will appoint the
Mayor
members.
will.
That's not what it was.
Okay.
Now it
It was
says
something
township committee,
else.
which is rather
I see. Got it.
vague.
I got it.
Yeah.
Yeah. I think those are the main things that we were looking at. I particularly wanted to, so if we were to go through this, to kind of think about what would happen, right? So something would go before the planning board. We would, if an application comes before the planning board, we have some, we can consider guidelines. We could also, we can also ask the Historic Preservation Committee for input at that point?
Yes.
And that's to me what I wanted to kind of talk about.
Sure. I mean, right now, the ordinance says that the Historic Preservation Committee has the authority to give their opinion on applications. But there's no real process for drawing them in. It's not like we delay applications in the historic district and don't send them before the planning board. In fact, we can't do that because the municipal land use law says there's a certain timeline. If an application is complete, it's got to come before you guys. So oftentimes there isn't time. This makes it a little bit more clear that if there is an application in a historic district or in the local historic district, that it should go before the planning board, or the Historic Preservation Committee should give their opinion on it one way or another. We would have to figure out the process for doing that. My initial suggestion would be that if an application within the historic district came to Kristen, when she sent it out to the planning board, she would also send it out to the HPC. And at the very least, the chair of the HPC could take a look at it, contact the chair of the planning board and say, hey, this has some issues we should talk about. So if the application before the planning board gets extended and carries over from one meeting to another, maybe they can go to the HPC in between meetings.
Which
And if
we've
it-
seen happen.
And
when
if,
they weren't required, yeah.
right, and if it doesn't, if you guys want to approve an application, you can approve it conditioned upon that applicant at least visiting the HPC and hearing what they have to say. Because again, the architectural guidelines are just guidelines, so it might be worth the applicant talking with the HPC about what those guidelines are. And maybe the HPC can get them to sort of refine, their project a little bit.
Sam, where are the
Assuming
guidelines coming from?
In here?
The architectural guidelines?
That are, well,
We
there
will
are.
write them.
Yeah,
Okay,
what's the source for putting
the
them
way
in?
this was written, so like I said, I did the first draft.
But I haven't,
Then, I know, and then I met with Will Harrison, John Buckwalter, and John Allen, and then the four of us went through it, and that subcommittee made changes. Then that version went to the full HPC. They went through it, they made changes. So you're actually getting something that's been reviewed by several bodies. The guidelines that are in here are the best guidelines that I could find going through various historic preservation ordinances that I'm familiar with. I've written a number of these. And I'm not necessarily talking about ones that I've written, but whenever I do something like this, I try to think of towns that are similar to the towns I'm working with, and then I look at what their ordinances say. And obviously, I've lived here for 25 years, so I kind of know what the character is here. So I took the guidelines that I thought were appropriate for East Amwell and put them in here. And then, like I said, we reviewed it with these other committees.
Have we had any discussions with, because several of these historic districts are partly in East Amwell and partly in other townships?
Right.
So have we had any discussions with the other townships, so there's some consistency?
No, well, that's an interesting point. That's an interesting point. Because the local historic districts do not exactly mirror the national ones, because like you said, some of them go over the border.
yeah.
In addition to that, this one, this version of the ordinance says that our local historic district will include those 7 districts, plus any historic building that was built before 1941. Okay, so that would be outside the district, because, and the HPC is the one that brought this up, is there are lots of historic buildings outside those 7 districts. So they would also be part of the local historic district, okay? Have we looked at other, no, but that's probably something we should take a look at. I don't even know if those towns have guidelines, or even historic districts for that matter.
Well, I know Hopewell does.
That's right, they do.
Would the guidelines be triggered if somebody's just looking for a building permit to do siding, windows?
No, there's an exception here for routine maintenance. Routine maintenance is defined, and there's an exception here saying that, routine maintenance does not require any review.
Real quick, you were mentioning something about the National Register and the local register. Does one have a better say? Like if it's something in locally is on the National Register, does that mean the local Historic Society doesn't have any say in its upkeep thing? I don't know, you mentioned something about that. So there's two things. There's a National Historic Register and a local one. Is there interference in between these two? Are they both trying to do the same thing?
The objectives are the same. The overall objectives are the same.
Yeah.
This would create a local historic district, which we currently do not have.
Okay, gotcha.
But I think he may also be asking, is there a problem with the dueling jurisdictions?
No, actually, you sort of need both jurisdictions, because I can tell you, I've never seen a town have 7 National Historic districts, and that's phenomenal that you have 7. But if you went to get historic preservation money, like a grant for historic preservation, you would be hard pressed to get it, because the first thing they do is they look to see if you have a local historic district and if you guys are really taking historic preservation seriously. And because we don't have districts and even architectural guidelines, you'd be hard pressed to get a historic preservation grant, even though you have 7 national historic districts. So this should help you get historic preservation grant money.
Thank you.
Good question.
Can I just ask a clarifying question around the routine maintenance thing? If I were to live, say, in the Snydertown, Newmarket, Linvale district, hypothetically, would that mean that if I wanted to put, is it vinyl siding on my historic house, that the guidelines would stand in the way of that?
These guidelines aren't going to stand in the way of anything.
Okay.
Yeah. They're not gonna,
Yeah.
I mean, whether you're doing a big project or not going to stand in. All it does is it allows this board to take it into consideration if they're weighing the positive and the negative of a project.
Okay. All right.
But I'm assuming that the value then is that, let's say Matt's thinking of, fixing up the old mill in a certain way, but he's allowed to do what he wants.
Yeah.
But he might be invited to have a discussion with historical folks who said, oh, did you know that in, 1776 it had this, that, and the other?
1600 or
And-
something.
Yeah, I mean, I assume that's the value of having it, because then you can have a discussion and perhaps people try to, not put vinyl siding on a beautiful old mill, but.
Or at least match the reveal.
Yeah, right.
Yeah, I have to say, I mean, working with the HPC on this was the first time I really worked with them, and I was kind of impressed because you've got somebody on there who does construction. You've got a historic preservation architect on there now too, and they were both very helpful. They make really good comments, so I think they would be helpful to applicants as well.
And then maybe it's, in my mind, when Tam first, and I first talked about this, it seems like it's a good meeting of the minds, in that you have smart people who are offering assistance and giving you a big greater perspective of what you could do. And in that way, we're not mandating things, but there's a good discussion and maybe some value out of that as for that renovation construction part of it.
Right.
And, go ahead.
I was just going to say one other question, and this is just because I'm naive about how ordinances go into effect. Does the community have an opportunity to weigh in on proposed ordinance language? And I'm thinking specifically about people who live in these districts, hypothetically, who might have an interest in knowing what these guidelines will be that are not mandating what has to be done in their district, but that are now sort of would be imposed in some way on their district. So will those people have an opportunity to come and comment on this?
There's 2 ways you could do that. Typically, when an ordinance is adopted, the second reading at the township, so there's a first reading at the township committee, then it comes back to this board for consistency review. Consistency review does not require a public hearing, because it's just the board talking about what it knows about the master plan. When it goes back to the township committee for a second reading, that's when there's a public hearing. So that's when the public gets to weigh in.
Okay.
Some towns will have ad hoc subcommittees created, and they might pull people from these districts. And just like we've already had, 3 different groups, myself, the subcommittee, and then the full committee do this, you could have the ad hoc committee look at this if you want to. It's generally not advised that you just publish this draft to let everybody look at it.
Yeah,
because
no,
that
understood.
things just really get messy.
Yeah, no,
when
I'm
you-
familiar with that. It's
I mean, here, I think we might also enlist our chair to invite people to come when we're working on this, because, inviting people early on in the process, I think is good for the brainstorming phase, right? And gives them a chance to do it. I think sometimes if things are, presented even for introduction at the township committee, it's kind of baked already to some degree, and I think we want to make sure people know and get invited early. That's
where I'm.
I think we could do that here.
Based off the mayor's comments, I agree, because while the statute requires a public hearing the second time around, normally by the time that it gets to even introduction, like the mayor mentioned, it's been there's been a lot of work put into it, right? So especially, the community might even be more appreciative if you do have more input at the beginning stages like this. So by the time it is getting to township committee, especially on second reading, you've had a lot of input, and the township committee doesn't feel obligated to make those changes, on that second reading. They've already been made.
Is there any, and this is actually is more addressed to the township committee, is there any consideration being given to giving some sort of tax relief or something to people who are taking what no one would dispute is a historic building and saying to them, you know, if you restore this building, you won't, give you 10 years tax relief or something along those lines. Because it doesn't seem to me, I mean, there's some historic preservation going on in this town. There's some historic renovation going on in this town. They're two totally different things. When it comes to, and historic preservation usually requires the expenditure of a great deal more money than historic renovation, which is typically putting up a facade and then just tearing the shit out of the rest of the house and saying it's a historic building. I mean, as an example, anybody who knows this, knows that Brian Giles did the case wreck on the highway, and if you go into the house, I mean, he did an absolutely beautiful job, and it's a restoration. I'm not saying that
It's a good idea. I think,
So what you
Something for us to consider, that's for sure.
give some of these people who are willing to do restorations an incentive. We're clearly not going to hand out money. We don't have money to hand out, but to tax relief is very important, and that's done. I think that's done universally in terms of getting people to do these things.
And I was going to say, Tam, too, if once this is all enacted, right, if homeowners are looking to do those type of things, they would also be probably eligible for, maybe some grants and things like that, and be able to seek that relief. But the township at least needs to be able to give them the opportunity to do that by implementing an ordinance like this. So
Correct.
along those lines, at least, there would probably be more opportunity for homeowners to get some assistance, I'm sure. I don't know if you agree with that, but to get some assistance in some way.
Yeah, I haven't gone after a grant in a while, but yeah.
Yeah.
If the state's got money,
Yeah.
I think that's possible.
Yeah, I think it's a good idea, worth considering, and I think, to me, Tam made a great point early on when we first talked, which is, right now we have no ability to really be involved at all, and that seems to be a missed opportunity.
Yeah.
So I think, taking her up on her offer to present this and come up with some language and doing that, I'd be very curious, like you were, Candy, to think about what these standards would be like and where they come from, but I think the notion of giving us an ability to do that and yet not mandate things to people is great. So
Yeah.
I appreciate your work on this.
I agree.
I got small versions of this. I gave this to Kristen.
Is that this one?
We've got it.
Yeah.
Yeah.
Okay. You got it. Good.
Thanks. What colors are what?
Well, the stuff
the
that's
seven?
in red. I mean, what this is, I took the National Historic Registries, and it spells out which lots are in each district. So I used cross-reference that with the tax map, and I figured out for myself where these districts are. If this goes through, your engineer is
We'll do
going
this.
to have to take the nominations and basically do what I did, because you shouldn't trust me at all. But I at least wanted to see where they were. So anything that's sort of overlain, it's kind of hard to see.
But I do see where they go into West Amwell, Hopewell, to
They
your
do,
point.
and Raritan Hills.
Yeah.
I have to believe we have no jurisdiction, but I think to the point of coordinating with other towns, that's a great idea, right? Especially if, we come up with something that's pretty good. Obviously, the ones that just go across borders because they're, arbitrarily made for some of these borders, if we get them to work with us, I think that would be a helpful idea.
Well, certainly before the next meeting, I can look at the towns around and see what their ordinances say and compare it to what we've got in here.
I have one question. Why was 1941 picked?
Because
Some of us are historical or approaching historical.
I was already born, but
They that will live in infamy.
but I asked the question, you know, why 1941?
Because when you look at all 7 of the National Historic
I know,
Districts,
it's Gannacci's
the
birthday. That's
youngest
what I was
historic
talking about.
structure is 1940.
Okay. Thank
That's
you.
where we pick.
Thank you.
You want to base it on something,
Sure.
and that's a very logical way to base it.
So,
I mean, I think this is great that she's working on this and moving this forward. I mean,
Okay.
I'm not sure what you're contemplating for next step, but I mean.
I wanted to see if we all were in agreement in principle. I didn't want to just
Yep.
send, so I think the next thing is, I think if, I agree with, I don't want to send out an ordinance for have everyone start giving us feedback. I think I would maybe give it to a couple people for feedback first, and then send it out for everybody. My hope, what I don't want is like a bunch of track change, you know. If we start, but what I'd like to do is get it to people, if there's a lot of feedback, then we need to figure out how to adjust that, right? Do we have an ad hoc committee to address that feedback? If we're mostly there and there's small changes, then I would love to be able to say, you know, a month from now, we look at an ordinance and we decide, you know, it also needs to go through our professionals, but then we decide, are we ready to look at it? And then it would then go from there to the township committee. But if it's not ready, then we'll continue to work until we're comfortable with what we're sending to the township committee.
I mean, in my mind, I think seeing what the standards would be, I think for me would be a next step, because I'm very curious how that would work. And I think if we, this would be an amendment to our ordinance, right? Because we have something now.
Yes.
Correct.
So, I mean, I found that the easiest way to do that is actually taking the existing text
Got it for
and
you.
redline it.
It's all there.
Because, yeah, because that's really clear about what's changed and what isn't. So,
Yeah, I
so
just
thank you
didn't
for
want to
that.
take that and just send it to
Oh,
everybody without
yeah.
some initial conversation.
No, I'm talking
She's done a
next
lot of
steps.
work already.
Awesome.
I don't want to take that away.
No, and to be clear, this is the ordinance, but it's not in what we would call ordinance form. There's no whereas clauses, no signature lines. That still has to be added. So we're just focusing on the text itself.
Yeah. This is wonderful. You guys
And by the way,
did a great job.
if it's okay with the chair, if people have questions while they're reviewing this, before the next meeting, they're welcome
You
to
could
call
be
me.
the clearinghouse. That
And
actually
we can
comes-
have a one-on-one conversation.
That's actually the best way to do it, I think, yeah. That way
Yeah.
we don't have chaos.
Yeah. So
My biggest concern
anybody's
is-
welcome to call me.
Yeah.
How do they call you?
Kristen will give you my number.
Okay.
So next steps are, I did promise you I would share it with you, so I will share it with you. And if then you don't have any large objections, then I will share it with the group. If they have questions, we'll have a conversation with Tim, and then at some point, we'll make a decision on whether it's ready for us to consider it, to vote, to send to the township committee. If it's not, we'll continue. One thing I did in the document is I looked at all the different meetings, and I said, if we make every meeting and we don't delay, then it could be adopted by the township committee in November. And the reason I say that is because we go into the next year, so I do feel a little bit of, not urgency, but just awareness of the calendar.
Good.
So if we can, it's easier to get
Probably
something done,
smart.
get something done in this year. So I'll ask people to just consider that.
Excellent.
Perfect.
I think dealing with our historic buildings would be a great step forward, so that's good.
So now from the beautiful to the mundane. We have one more, and that is home occupation. Tim, I didn't put you on the agenda here, but I know you're familiar with this, so I'm gonna. So the home occupation, when we did our training a while ago, Tam attended, and I think this came up is that one of the things that came up was just there's some areas in our ordinances that are, I'm just gonna use the word messy, right? And home occupation is one, and that specifically where home occupation, instead of saying, here's a home occupation, and then you have all these conditions, it's basically, home occupation is something that has all these conditions. So basically, you've commingled the definition with the conditions. Am I making sense?
So you've sort of defined. up front.
Yeah, so now what we're proposing to do is just edit the definition for home occupation to make it very simple. I actually grabbed something in here, I think I grabbed it from another township. And I said, if I put it in here, I don't know, maybe I didn't. But a very simple, short definition of a home occupation. Then change home occupation from a permitted use to a conditional use. Take all the conditions that are already in the ordinance, listed as parts of home occupation, and lay them out as the condition. And then add one more thing where home occupation must be an accessory use to a residential right now. And I think there's one more. So basically, and what I did, what we're trying to do is just clean it up. We're not, in this particular case, unlike with historic preservation, we're not trying to make any new policy, we're not trying to make any rules. We're just trying to say, here's what it says. We're gonna make it say it more clearly. Yeah, I'll just leave it at that.
So are you saying it would be a conditional use?
Yes. Right now,
And
it's.
so what does that require procedurally for someone?
So conditional use is something that it's permitted in the zone, but it has to come before the planning board and meet certain conditions, right?
So if Al wants to, do some tax work in his house, currently he can do it if he meets the requirement, but now he would have to file an application from the planning board? Is that
Yeah, I
really
mean,
what
he
we
still
wanna
has
do?
to, and I don't know how it's phrased currently in the ordinance, if it's a
it's in this
conditional
long
use
freaking
or.
document somewhere.
I don't think it is. I think it's
Yeah,
just.
so it would, and the thing is
so-
with conditional use is it is a permitted use in a way, but you have to meet each and every condition, and if you don't, then you need a special type of variance in order to
Because
get
I
that
think
use.
philosophically, I'd be more comfortable saying, home occupation means, lay out whatever it is, lawyer, sewer, do whatever, of X amount of square foot inside a home, and so that people wouldn't have to, it says, oh, if I satisfy that, I can do it, rather than saying, Dante, you have to go in front of the planning board and do it, because that seems onerous to me.
Yeah, you don't want to come from the planning board.
No.
Yeah, I've met them.
Maybe I can help here a little bit.
Yep.
As Emily said, currently the definition of home occupation lists all the conditions in the definition. Problem with that is you can't get a variance to a definition. So that's actually an illegal ordinance. If you have a permitted use that is only permitted under certain conditions, it is by definition, whether you call it a conditional use or not, it is a conditional use.
Right, but doesn't one require you to file an application and one does not?
No. If you have a permitted use, if you have a home occupation and you satisfy all the conditions, you do not have to come before the planning board. You can get a zoning permit. The zoning officer will say, okay, you satisfy all these
Yeah.
conditions, and you can get your zoning permit.
So if someone wants
It's
to
only
like,
when you don't meet those conditions.
so if someone wants to fold up flags and package them and send them out from their house, right now, they can't just do that. They have to get an approval?
You'd have to be licensed, I would imagine, first, right?
Well,
Well, but you don't need a license to sell things, right? I mean, my understanding was so long as you don't have 20 cars parking there every day and you don't cause traffic, you can do it because it's kind of like you just living in your house except you're selling flags. But if that's not the case, then I'd be interested in that because I don't sense our residents want to be applying for applications if they're doing something in their home.
I have another question about that. A lot of people sell on eBay,
Right.
and they do that kind of as secondary business.
Right.
well, usually if you have a home occupation, you have registered your business with the state, okay? I can tell you, there are a lot of people who have home occupations and nobody knows about it.
Yeah.
If nobody knows that you're doing it, nobody's going to even
Right,
come
but
for
I'm
a
more
zoning
concerned
permit.
about what we think the legal requirements are, because let's say if someone is selling stuff on eBay, in my opinion, if they're not bringing loads of customers there and clogging the roads and parking everywhere, I'm fine with that. I think that's a home occupation, and that's my. But if that's not the case, I'd like to know that because I don't want people coming in for
Well, and we can
permits.
finesse all that when we create the new definition,
Well,
okay?
but I'm trying to figure. I want to figure out first what problems are we solving,
There you go.
Well,
right? And so I'm
the
not.
problem-
I'm not sure I know what problem it is here.
The problem is, number one, the ordinance is illegal, and number two, because the conditions are in the definition, if somebody doesn't meet every single one of those, they now need a D1 variance, rather than a D4 conditional use.
I think it's 4.
A D4. And a D4, the proofs are much lower than a D1. A D1 is the
Significantly,
hardest
yeah.
variance to get.
Well, let me ask it this way, as a legal question. What's the easiest way, simplest way for people to do things that don't interrupt, don't inconvenience their neighbors
So-
without having a lot of process?
So I think the reality is it's just like any other zoning issue. If you're not causing a problem, you'll probably never know, right? So the reality is if someone's having that flag business they're selling on eBay, you'll never know and they're just doing it and technically it's a zoning violation, but you don't know about it, you don't hear about it, right?
Exactly.
Yes, but what
It's like everything is
but
illegal, but enforcement is
I think what is
discretionary.
being proposed, it
Yeah.
actually makes it an easier burden for someone who is actually doing it, because like Tam said, it's in the definition, right? Then the use that you're proposing, right, if you don't meet every single item, you would have to get a D1 variance for that, right? Because the use, right, so say, give 3 conditions, right, 1, 2, 3. Say, and they're in the, as written now, right, in the definition. Say you don't meet 2. As a result, you don't meet that definition, so now it's not the appropriate
No, I get it.
use,
It's
so you
just
have
hard to
take
talk
it.
in the abstract. I'm still
Yeah.
stuck on what I think I'm hearing, which is that if someone wants to sell some things on the phone at home, they need to get an approval because technically it's a violation and.
That's the case today.
Yeah, but I think it
Yeah,
also
that is
depends
the
on how
case.
it's
So-
defined.
So, but that seems to me a bigger problem to solve than this other thing, because I don't know that we want that.
It depends on how it's
Well,
defined.
Yeah, and it's not like you don't have a process here where everybody has to register their home businesses. I mean,
Well,
some
but-
towns would have that, and then you could go after them. But generally, you're not going to go after someone who's violating the ordinance.
Well, whether we go
unless it's
after them or
creating a
not,
problem.
I don't want people potentially at risk because now they've got to do formal things if they're using their phone or their computer to do work. Because
Yeah, but the bigger problem is if you don't have some restrictions, you're going to have people doing things as home businesses that are.
I agree,
going to
but
create problems.
isn't that traffic, noise, pollution, those things? But to me, that has nothing to do with. So I mean, why aren't we just defining it? I mean, I think it's probably too hard to do in the concept. I would rather maybe we should look at what it currently says, and if people
That
say
is in the document that I sent you.
Yeah.
Did you read the?
Yeah.
I'm just kidding.
No, I didn't see our current
No,
step.
so don't.
I wasn't sure what that. I didn't think.
That's
I
what
didn't know
that
if that
was.
was the
That-
proposal. or
No,
was-
that was, what it had, for the home occupation, it said, here's the problem, here's what it currently reads, here's how it would read if we changed it.
that was
Because,
redlined. I didn't see
no, it was not
Oh,
redlined.
that's
That, because it was not, I didn't give you the whole 20 pages of the ordinance. I just gave you the 10 lines
Okay.
of the ordinance that we would
Cool.
change. We
And
can
there's really
redline.
only one new condition.
Yes.
And that's that home occupations must be accessory to residential.
Which is
So
typical.
you-
But I think what he's saying is a little bit, I hear what you're saying. You're saying right now it's permitted use, you don't have to do anything.
Right.
And now you're saying it's conditional use.
Right. And now there might be applications and requirements, and I'm thinking, can't we just define
no,
what is
look-
acceptable to do in your home that's not exactly residing, but neither is it industrial nor office park, right? So that it really doesn't bother the neighbors to be selling on eBay or packaging up flags and putting them in and going to the
So,
post
I
office.
mean,
Well,
I think that,
Yeah, first of all, we're not creating a new regulation. I mean, under our current ordinance, unless people meet every single condition within the definition, everybody's violating it.
I know, but that's what I don't like. That's
why
exactly what
we're
I'm trying to get
fix it.
around.
That's what we're trying to fix.
Right, so you're just trying to
well,
clean
but-
the ordinance up, correct?
Yes, correct. We're not trying to change.
All we're doing, we're not
Well,
changing anything.
well, but I'm saying you might need to change it if right now people are really supposed to be filing applications in front of the planning board to do it. If that's in how you're interpreting the law, I
No,
think we
they're
should
not.
change
They're
that.
not.
They're not.
It's only
That's not how we're
for the
interpreting it.
board when you need the way it's written, the
Yeah.
problem is the way it's written is you can't get a conditional use variance because they aren't conditional. Right now, they're all in the definition, so you'd have to get an actual D1 use variance, which are 2 different standards.
Well, why do I need a variance if I satisfy what the definition is?
You
Or
don't.
just
You
redefine
don't.
it. Why can't you just say that a home occupation is permitted unless it creates these externalities?
exactly.
And then
That's
you
how I think
define
of it.
the nuisances that you
Right.
want to prevent, and then it's more permissive.
Yes, I agree. Because if you're doing stuff that doesn't bother the neighbors, I'm fine with that. I don't care what my neighbors are doing. Just don't bother everybody else or cause problems.
So are you saying, so right now, what it says is, I'm gonna just pick
Yeah.
one, right? A home occupation shall not in any way alter the residential character of the neighborhood, nor
Yep.
in any way adversely affect the safe and comfortable enjoyment
Yep.
of the individual property rights of the neighborhood in which the use is located. That's right now.
Okay, that's good.
That's part of the
Okay.
part of the definition. We're just saying
Mhm.
now it's a condition.
No, it's a condition.
Well,
And what does
so
that
you
mean?
could just say a home occupation is permitted unless it. So you start with.
Unless, okay, yep, that's,
Well, who's gonna be the judge of that?
yeah.
The zoning.
Are you gonna
Yeah,
enforce
exactly,
that?
zoning. If the
The
neighbors say,
zoning
the
officer
Bureau's
can
way
enforce
too
that.
loud with this, that's a problem.
The zoning officer is not gonna make a judgment. The zoning officer is gonna read your ordinance
Yeah.
and,
Say,
If
is
it-
that
if it
disturbing the
says-
community?
you know,
Yeah,
it's gotta be
noise.
defined. The zoning officer is not gonna make a judgment.
60 decibels. Gotta
Exactly.
Be under, like,
Exactly.
I mean.
Yeah, you're
you
just
know.
right.
Exactly.
Which is also notoriously hard to.
It's also the choice.
When you talk about nuisances, they're the hardest things to enforce,
yeah.
so.
Well, all I'm saying is conceptually, I think we should not be making people apply every time they want to use their house for something that's not purely residential. Other than that, I'd look at whatever it is. But I think we gotta make it easy. I make it simple.
And
Aren't we-
I think we can do that
aren't we
with the
saying
definition.
that we're making an exception for commercial use in residences, right?
Mm-hmm.
Right? We have made such exceptions with respect to barns, right? And,
Mm-hmm.
but we're very, very specific in terms of when we did that, we made people comply with commercial requirements. So if you wanted to use your barn for an antique shop or a bed and breakfast, so the only two permitted uses for a barn that was over 75 years, and that this ordinance goes back, because it was the impetus for my doing my barn, quite frankly. Didn't give you any money, but I remember initially having to listen to some of these folks like say, send me 52 conditions in terms of being able to do it. Township engineer in terms of lighting, parking lots, I mean, went on and on and on. I remember standing before this board and saying, I'm here to make sure that this is what you want. And someone on the board rather rudely says, if that's what the township engineer says, that's what we want. And I said, good. And I said, how much asphalt do you want for the parking lot that he suggests for 50 cars? And one said, asphalt? and then the rest of the board, the ears started perking up. And I said, and the lighting, I said, there's some very nice lighting at Kmart. I said, assume you want the same kind of lighting. And they went literally, of the 52 things, right, they waived 51. And I said, I'm glad I'm here because I would hate to have be here later when you're saying, why the hell did you ruin this goddamn property in this barn? But the problem here is, look, somebody who has parking is not going to have a problem if they have a quote unquote, they're teaching voice lessons or dance lessons or whatever, and because they can. But 2 cars, if you live in downtown Ringo's and where there is no parking on the street, 2 cars in front of your house could block the whole goddamn town. So it's a very dicey proposition when you allow commercial ventures, because some people, for most people, it's kind of, I'm working from home, or I teach voice, or I teach piano, and it's all wonderful. But Now you have other people who then decide that, well, I'm going to teach ballet and I'm going to have 13 children who don't come alone. They come with at least one of their parents and in one car, and and all of a sudden, especially as I said, if it's in downtown Ringo's, where are you going to put where are they going to put the?
Well, anyway, you want-
It does
anyway, you want
specify.
to proceed.
Yeah, here's what I'm gonna propose.
Limited to
One student. I know what it says.
I'm looking at
But
the
that
time. Here's
never-
what I'm gonna propose.
How can you limit it to one student?
Michelle,
one student
you're gonna
at a
get
time.
gavelled over
There,
there.
yeah.
All right. Anyway.
Here's what I'm gonna propose. From a priority standpoint, I put 2 in front of us. I'd like to ask that we will work on the historic preservation, and then I would like to ask you just to read the document that I wrote and give some thought as to what I'm hearing is, I want home occupations to be allowed under certain conditions, and I don't want them to have to get a permit. So, read what is going on today, read what we're proposing as a change, say, does this make sense? Or do we want to revisit this entirely? And I'm not suggesting that we'll write an ordinance right now. I just want to get some agreement and concept of what is it we want. And I think what Jamal said, to me, makes sense. You can do it if as long as it doesn't do these things. Like,
Yep.
maybe, I don't know how you write an ordinance on that, but if that's the concept
Well, I
we
think
want.
maybe someone can pull a couple, look at Hopewell's or look at Raritan's or something. I mean, because
Wait.
obviously folks are doing this, and so I'd be curious to see some of those approaches, because I think a soft approach is really what we want.
And just to add, in 2020, some significant portion of this town was all working
Oh,
from home. I mean,
exactly.
let's
We
be
were
real.
all
It was just
over.
all that, right?
Yeah.
Which is no problem.
Yeah.
if there's
So,
not-
so, I mean, the original thought was, let's just make the ordinance legal. Don't change anything, just make it legal. And that's why we were talking about moving it from permitted uses to conditional. But if you want to do more than that, we can certainly do more than that. And
that's kind of
we
what I'm
and-
hearing, is that we don't want to just make it, we want to
Because
revisit it.
maybe a sample from Hopewell, for example, if it does what we're talking about, and it already does what you were saying, because it maybe defines it in the way you thought was good, and if so, we could consider that.
I can put together a sample from a number of different towns across the state.
Sure.
And again, I'll try to pick from towns that are
Similar.
similar in character.
Mhm. That's great.
I can do that.
Thanks.
Thank
And
you.
I'm gonna ask, once we do that, you and one other person to weigh in, Jamal, to weigh in on it
Yeah.
before we bring it back to the larger town. I'm making an ad hoc committee right here.
Yeah.
I'm
Yeah, totally.
appointing you're voluntold to this committee.
Jamal and Rich, I think we were big mouths, so we got called out.
So
All right, so be it.
Go
Where are we
chairperson.
gonna see this? You're gonna email it out?
When it's ready, it will be emailed out. It probably won't be emailed to all of you because I don't want to have a quorum by mistake. So it won't be done individually, but we will get it to you so you can start to consider it.
Thank you.
And we'll go from there, but I'm not gonna try to bring it back next month. I think I'm gonna try to bring back historical. We'll take a little bit more time with this one. Are we all good?
Good.
Okay.
Sounds good. All
Good
right.
suggestion.
Thank you,
Thank
thank you for the discussion. What's left on the agenda?
So moved.
Oral
Oh, sorry.
report.
Oral reports. Anyone-
Nothing from Ringo's.
Yeah.
So-
Okay, anything from Environmental Commission? Make
There's
it
a
short.
proposal to merge with
Oh, right.
recycling, and I believe that has been fully discussed, and it's coming up to.
They just
the-
sent me a draft of it, but I haven't looked at it.
It's really.
I'm curious,
I
did
think
you
it's
see it?
really
You like it?
good. I
Okay,
like
good.
it. There's the Environment Commission, they have an agenda. They're working. They're doing stuff. I think it'll actually kind of
Energize.
breathe more energy into the Environment Committee, and
Okay.
you guys just have to decide who the voting members are going to be. I think that's
Because I think by
by
statute we have to, right?
statute we need to have so many voting members.
Okay. All right, thanks for your work on that. I did see it come in an email, I just didn't look at it yet.
Agriculture or FOSPA, that'd be you too, right?
They so we still haven't heard back from the state on our report. Or we didn't have the meeting this month, but I think that's hopefully imminent.
And Historic Preservation Committee, we just got that update. Just for the record. Anything from you, Kristen?
Only if anyone is not signed up for the news flashes, to please sign up for the news flashes so that you'll receive important township information
Where do we sign up for those?
on our website.
On the township website?
Yes.
Read about it in the news flash.
I don't have anything other than just to say thank you to this committee for
Endurance?
endurance and also just, I think there were some differences of opinion, and I think one thing that's really important to me, and if I could get us all to wear shirts, it would say, be nice. I think we can absolutely disagree, but keeping it respectful to me, and I think we did a pretty good job of that, if not a perfect job of that. And I think that I'd like to continue that model. I didn't expect, maybe very naively, didn't expect this to be so difficult. But I do really want to hold us to that level of being respectful and being nice and disagreeing on what is it like?
Substance.
On substance, yeah, and not making it personal. So I appreciate that, and I just want to say thank you. And next month, we will be picking up where we left off with Monahan. May I have a motion to open to the public?
So moved.
May I have a second?
Second.
All in favor? Open to the public? Come on up.
Wow, you've been patiently waiting the whole
Right.
time?
The application is like,
And I don't even know who you are.
well, I don't know who you are either. I'm Frida Ralph, One Linville Road.
Oh, I've heard your name many times, yes.
Okay, and my question is for Tamara Lee, of course, and it has to do with the historic preservation. And I know she said she's looked at lots of towns with their ordinances and whatever, and I happen to have a friend who lives in Crosswicks, New Jersey. And she has an old house, and I know a lot of the restrictions that were done. For example, she put in solar panels, and the old historic house, not on that house, but she had a newer detached barn, and she was allowed to put it on the south side of that. And so it was it's a very old town, it was Quakers, 1600s, whatever, and her house is 1850. So that was just my question of her. And I guess, open to the public, can I talk about something else? Not about her? Sorry. I have a
only say
question
nice
because
things
one
about
of
her.
my pet peeves is lighting. Is there any plans to work on the lighting ordinance or whatever? I have actually had the zoning officer send a letter or a soft approach to Unionville Vineyards, who drives me up the wall with their lighting, with all the ash trees that are down, the lights that are on at night, glares into my master bathroom and a bedroom on the east side and my room downstairs. And there's just other, newer houses that have come in that they're very proud of their big, beautiful houses, and so they have these lights shining all the time, not motion sensing, Linville Road.
Yes.
And so, things have changed in terms of, it used to be that your lighting was, well, first of all, Unionville has solar lighting, so they don't care. But it used to be that people cared what their electric cost, but now with LCDs, it's not very expensive to leave your lights on all night. And some people do. And I do my garage light sometimes when I forget it. I have a motion sensing outside, but my inside was like, oh my God. Anyway, that was it.
Thank you.
Anyone else? Come ahead.
You could say no, Francis.
It isn't
You could
easy.
say no.
Yes,
It wasn't obligatory.
No, I came here wanting to say what I'm saying.
Excellent.
I think some of you know that I found the paperwork that supposedly didn't exist for the solar greenhouses that go up on Dutch Lane, and then with the wanting to go over to the grade school for electric and then get grants and things like that. What didn't exist did exist, and I passed it on, I think, to you, the documents that I found, if that didn't get through. But something that it brings up to the forefront is that just as you have a warehousing ordinance that you need to do, then with greenhouses or other farm buildings, to put something on that would restrict
light pollution from them, especially if they're going to be on the ridge and in the view shed, to where that if you are going to have a solar greenhouse or greenhouse, then it should be constructed in such a way as the light from within not go outside of, it's basically, it's a dark skies ordinance, and Colorado has a whole bunch of them, and I think since there's moving forward with it, then that is something to get on your books to protect the night skies and the viewscape sooner rather than later, because there were at least 3 properties. There was Backbrook, and there was Dutch Lane, and I think there was another Thompson Land property that they were going to do this with. So to put, I don't know if it's the 100 acres behind you or not, but that would certainly be a joy.
Are you referring to hoop houses or solar?
Hoop houses, greenhouses, if you're going to have a lit structure, farm or otherwise, then the light coming from it should be shielded or mitigated to where it does not become a string of Chinese lanterns, whether they're hoop houses or whatever. And that's certainly something that they can do to enclose them. If they're going to have solar panels on the roof, that would provide the cheap electricity, but just, protect the dark. Huh?
Why not just grow them in the sun? Why would you do that?
Because you can't get the huge monstrous strawberries that the New Yorkers all like to have coming from vertically grown hoop houses. I can't explain the logic of New York City. I can just complain about it along with everybody else. Why do people move out here and then fence every square inch of their property so Bambi goes on somebody else's lawn? I don't know. But I do think you do need to protect the dark skies, and drafting some kind, whether without going into the full lighting ordinance, just to say that as a matter of policy, that structures, agricultural or otherwise, that would be lit should be in such a way that they do not extend and become, a source of light pollution. And I have seen at times, and I think I mentioned this to you, Dante, a while ago, there have been times when that indoor that's across from the school, that I don't know what they're doing, but the light that would pop out of one end of that indoor was visible all the way down at Totten's. Not all the time, but if you had something that would manage it, it can't hurt.
Thank you.
Yeah, that's it.
Go ahead. Go ahead. She had her hand up first.
Just a quick addendum to what she said. I spend my winters in Tucson, Arizona, and they have had an extremely strict lighting ordinance to protect their dark skies for 50 years or more. And except for Christmas decorations, the old historic parts of Tucson, it's dark at night. It's not like, I live in suburbia, so unfortunately I have to deal with neighbors. But anyway, dark skies are worth protecting, and there's so few places on the East Coast, that had dark skies. We had dark skies when I moved here. Thank you.
Go ahead.
We have a dark sky ordinance. It's been in place for many, many years. Floodlights that are not on timers have not been legal in East Amwell for a very long time. It's just nobody's enforcing it. And there is also a lighting amendment that has been drafted to include hoop houses, greenhouses. My understanding is, and Dante, you can give me more detail on this, but I heard there was someone or some people on the Environmental Commission who were objecting to parts of the lighting ordinance, not the proposed changes, but parts of the existing ordinance. And from the way it was explained to me, I think they were misunderstanding the ordinance. So I'm really not sure why that proposed lighting amendment hasn't gone further.
So folks on the Environmental Commission were confused with the language, and therefore had concerns. And then the other issue was, we've been consulting with farmers to see whether there would be an effect on them. So far, I haven't heard any farmers who are using greenhouses that are lit at night.
The only thing I can think of is people that are doing hens on pasture sometimes use a mobile hen house, and those have like cattle panel and it's opaque, and in the winter they supplement the amount of light so they continue to lay. We don't do that. They go into an old riding arena, but some people, there may be some supplemental light a couple hours in the morning or the evening, and those structures are opaque, so that
So some light gets out because they're opaque?
I would think so. They
Yeah.
glow a little bit.
But
So so if you know who,
That wouldn't matter because it's not like the lights are on all night long.
No.
That's what the ordinance.
And they're not.
so
Right.
Jamal,
Right.
if you know some folks that do that, I'd be curious to talk with them, because we had some concerns that we might be unintentionally impinging on some folks.
It sounds like it's not a worry.
Well, but I'm not sure because we haven't gotten a lot of feedback.
Right.
The folks that I did talk to who were farmers, and Mike Dendis reached out as well, they didn't have a conflict with it. But it's significant enough that I want to make sure that we can see whether it's going to gouge
I just
somebody.
I don't know anybody locally who's growing anything that's worth enough money to supplement with grow lights in the evening. You know
Are
what
you
I mean?
swearing to that? No, I'm just kidding.
I mean, it's not that's allowed.
Yeah.
And if there
That would be good confirmation to get. So if we had something that was clear, so folks knew exactly what it was and what was new versus what's already in the ordinance, and that if it didn't, unfairly gouge farmers, that would be great. That we could. So, but that's the kind of research that we're doing.
We can ask NOFA. I can
If you would ask, that would be
Devin.
very
Yeah.
helpful.
Yeah, and I
Thank you.
think the red line version is available, and I am aware of some of the language that people were concerned about, because I happened to be sitting there overhearing the conversation, and it was existing language that was it was
Right,
people
and,
just,
I
and
think,
that's where
I think that was part of the problem of having everything together, old stuff and new stuff. People couldn't, members of the public and
Yeah.
members of the Environmental Commission couldn't figure out what was different. So I think, something that would just say what we're doing in this one would be more helpful than that. And then, again, I want to make sure that the folks in town know what's in it. So we've dealt with those issues first. So if you can find out something, Jamal, that would be helpful. Thank you.
And if people on the environmental commission are so confused, I'm happy to meet with anybody to talk through the ordinance. Let's do it this year.
I guess all the public has spoken now, so may I have a motion,
So
to
moved.
close to the public?
Second.
All in favor?
Aye.
And may I have a motion to adjourn?
So moved.
Second, all in favor?
Aye.
I'll use it. We're adjourned.
Good job.
I've heard your name, and I actually think you have been here before, I just didn't remember.